Senhoras e senhores, boa tarde.
Ladies and gentlemen, good afternoon. To resume this international conference on monitoring, electronic monitoring technology, ethics, and the guarantee of rights. To this afternoon panel on home arrest with electronic monitoring, we invite the speaker Roy Murillo Rodriguez from Costa Rica and Fernanda Oromasso, who's a judge. We hand the floor to to the judge. It is a great pleasure to be part of this conference that is promoted by the National Council of Justice as well as the Program of the United Nations for the Development. Minister Ribeiro Dantas has the floor. We would like to salute the organization, to commend the organization through the President of the Supreme Court and the National Council of Justice, Minister Rosa Weber, as well as Dr. Katina Agueta, who is the representative of the United Nations to the development in Brazil, UNDP. So let's start this panel, which is the first panel of this afternoon on home arrest with electronic monitoring. It's the third panel composed by Dr. Roy Murillo Rodriguez and Dr. Fernanda Orsomasso, who's here with us on the panel. The objective of this discussion is to bring light over the relationship between two measures of criminal responsibility, monitoring and the house arrest. Because only in 2020, the Ministry of Security and Public Safety started to publish information, disaggregated information on people who were under EM and house arrest. And then there was an incorporation of these data in the data bank of the CISPEDEN, which is a national data bank for penitentiary data collection. And we haven't had the opportunity to make a comparison of these measures. Therefore, we lack systematic information regarding the application of both tools. We call your attention to the fact that these pieces of information were only made public in the year 2020 while we were having the pandemic, when through the advancement of the pandemic, a bunch of measures of mitigation of the virus in the prisonal environment. That was a moment in which all of those who were in jail, they started filing habeas corpus requesting house arrest or transference to another form of paying their debt, among which the replacement of measures that restrict freedom, whether through electronic monitoring or house arrest. And so when this data started to become public, in the very short time between the second half of 2020 and the second half of the year 2021, which was the last deadline of the collection of data from CIDE Spain, two aspects could be observed. First of all, there was an increase of the application of both measures. The number of people under EM grew 25%, going from 720,000 to 91,362 people. And the number of people who were under house arrest increased even further, about 30%, from 139,010 to 183,603. So this is an aspect to be observed. The augment in more than 25%, reaching 30% of people who are under EM or under some sort of house arrest regime. The second aspect to be observed is the proportion of individuals submitted cumulative, in an accumulated fashion to these two measures. About half of the people in house arrest are simultaneously being monitored via instruments, among which the most common is the shackles. So, considering the criminal policy from a more systematic, integrated standpoint, what do these evidence bring? And this is what we are going to discuss in this panel. And what this data lack to show? What functions, what impacts are there that need to be debated for the sake of a criminal justice system that is centered on the insurance of rights? Or is everything all right? To contribute to this topic, we have Dr. Doyle Muri, who is a judge of execution in Costa Rica, and Dr. Fernando Orsomaso, who is a judge in the state of Paraná. As Dr. Roy is a little late, the organization asked me to invert the order, and we are going to hand the floor to Dr. Fernanda Somasso. Dr. Fernanda Somasso is a master in human rights and public policies via the University of Paraná, and she worked on coloniality, a state of exception, the reproduction of inequality in the penal system of Brazil. She's an expert in philosophy and human rights via PUC Paraná, and she's also an expert in penal jurisdiction and prisonal system via the National School of Training of a Magistrate. She's a collaborator of the group of monitoring and inspection of the prisonal system and the system of social educational measures application by the state of Paraná. She's also the member of the steering committee of the National Council of Justice, and she is also the deputy member of the Interinstitutional Observatory of Law of the state of Paraná. She is also a writer and a columnist in many newspapers and journals. Dr. Fernanda, you have up to 25 minutes for your talk. Good afternoon, ladies and gentlemen. First and foremost, I would like to say it's a joy and a great pleasure to be here today. I'm really grateful for the invitation that was made by CNJ and the UNDP. I'd also like to extend my greetings to all of those authorities who are here through Minister Ribeiro Dantas. I'm an admirer of your work, your excellency. You are an inspiration to anyone who desires to have a justice system that is more even, that is more equal and more committed with human rights. In the beginning of this conversation, I believe that it's important and convenient to bring clarity on the hypotheses of house arrest that are foreseen in the law in Brazil, so that later we can get into the problematization and reflections on the subject. House arrest in regards to provisionary prisoners, in other words, those who are expecting to be tried, was put into in Brazil in 2011, and it's meant provisionary arrest in which people would be in their house expecting for the trial. So first of all, I believe it's very important that we clarify that house arrest is not, I mean, a house arrest is an arrest. It's just like preventive arrest. It's like I said, it's like a provisionary measure. It's one in which the person is arrested. It's only that the person is not in jail. They are just at home. So house arrest is not a precautionary measure or an alternative one. And this is why it is not among the the instances in the penal code. And with the legal framework that was approved for children in 2016, in addition to provisional prisons of people who are over 80, it was also extended to pregnant women in any condition, as well as to women with children up to 12 years of age, among other hypotheses. There's also a provision that the judge can, in accumulation to the house arrest, also apply some precautionary measures, among which monitoring EM, which is a precautionary measure that is an alternative to an arrest as it is foreseen in the penal code. Now, for those defendants who have a definite arrest order, house arrest is only should only be given to those who have an open regime. Now, the STJ also accepts to people who are in closed regime, so long as some requirements are observed. So, once this panorama has been given regarding house arrest in Brazil, I would like now to deepen and direct my talk to the situation of women who are expecting to be tried or who are in house arrest in Brazil, and I justify my choice. As soon as I received this honorable invitation to be here talking to you and debating about this subject, I was informed about the theme of this subject of this panel, which would be house arrest with EM and practical dysfunction. And so, as I became aware of the subject or the theme, the situation of women who are incarcerated came to my mind. To me, as a judge of penal execution for more than 10 years, as a judge a penal judge for more than 10 years, as a woman, it was impossible for me not to make this linkage almost automatically. And here I would like to say that I do not disregard the situation of other people who are deprived of freedom in Brazil. Arrest or prison is suffering. It's actually a redundancy to talk about prison and suffering. It's physical, spiritual, mental suffering, not to mention sickening, especially in a country that has the third largest prisoner population in the world, which according to data from 2013 still has to live with more than thousands of bodies that are deprived of freedom, out of which more than 40% are still waiting for trial, people who are in degrading and indignant conditions. And before such a challenging arena or scenario, I chose to talk about women, and especially black women. They represent the most vulnerable share of our punitive system in the so-called war against drugs. We cannot talk about women in jail without talking about the tough war. The phenomena of super incarceration in Brazil is the result of a selective and punitive and racial system that was aggravated by the worsening of this war against drugs, which starts in 2006 with the approval of Law 11,343. From the enforcement of this law, the number of incarceration increased among women. According to IFOPAIN, in the year 2016, the number of incarcerated women corresponded to approximately 6% of the prisoner population in Brazil. But here, it is important to mention that the female incarceration in Brazil during this period between the year 2000 and the year 2016 presented a growth of almost 700%. During the same period, the prisoner population among men grew about 300%, half the number observed among women. Within the international context, in absolute number, in 2022 we had the information that Brazil is is the third runner among countries that incarcerate women in the world. We're only behind the United States and China. We're even more than Russia now. Most of the incarcerated women in Brazil are women, young, black mothers, who come from social strains that are very vulnerable, with low school scholarization. They are house owners, they are housewives responsible for maintaining the family, working informally before being arrested, sentenced, or answering to crimes related to dru- drug trafficking. 62% of drug 62% of the women who are arrested or sentenced are arrested because of some crime related to drug. And this profile of women in jail in Brazil reveals that we are before a process that researcher Dina Alves calls feminization of poverty and racialization of punishment, through which women with very low possibility and work perspectives are obliged or influenced to submit themselves to terrible jobs that are crimes. The nature of the crimes that are committed by these women, most of them, as I said, committing crimes related to drug dealing or something like the stealing of other people's properties, shows that there is a question for a complementation of their income, since most of these women are the single providers of their family, they're single mothers. We notice that the inequalities in the hierarchies that are verified in the family are also reproduced in the world of crime, with women playing secondary roles in the sales of drugs, falling on their shoulders a greater vulnerability and the possibility of repression due to the exposure. So it's not difficult, as we read the news, women who are used as mules or women who try to enter prisons with some sort of drugs. So to talk about women in jail means talk about vulnerability and invisibility as well as abandonment. And this is why I've chosen to talk about this issue. Now, with my justification, now I will get into the issue of house arrest for women who are mothers or who are pregnant. The arrest of such women was recognized by justice in great number in 2017 when the Supreme Federal Court, through a habeas corpus, allowed that Adelma Selma, the former wife of Cabral, left prison to be close to her children while waiting for the final decision of the accusation upon her. So this year, at that year, there was already the provision of replacement of arrest for house arrest for mothers as well as pregnant women. But the law had not been observed. So in the year 2018, a historical decision, the STF provided a collective habeas corpus ensuring the right of house arrest in favor of all pregnant women or mothers with children of up to 12 years of age who were in arrest in Brazil, except for those who had committed crimes that were very violent or against their children, or in exceptional cases in which the judge should communicate their decision to the STF or base their decision. Now, as for definite arrests, as I said, the law of execution foresees the possibility of house arrest only for those who are in open system. However, the STJ, through an extensive understanding of this habeas corpus, has admitted the concession of house arrest to women who are also in closed regime, so long as there is ponderation by the judge. A few years later, even with the law, in spite of the habeas corpus provided by the STF, there is still a lot of reluctance in its application. What is observed sometimes is that the cases are tried from an analysis of the behavior of the woman and not from the right of the child to live with their mother. So under a legal, and what they're doing is judging how a woman behaves as a woman regarding their motherhood. So the motherhood is being tried. According to some data of a research made by the CNJ in partnership with the UNDP in 2002, showed that one-third of pregnant women are still incarcerated after the custody hearing. And what we observe is that when there is a substitution of precautionary prison for a house arrest, so it's like as if the court was providing some sort of a favor. What is she complaining about? It's just as if it were some sort of benevolence and not a recognition of a right. So even after all this pathway been run by women who are mothers and who are pregnant, even after so many times they actually needed to prove that they are indispensable for the care of the children, still there is room for these women being seen as privileged. And this is where another battle starts, which is very complex for women who are serving time or wait or serve time at home. The challenge is to survive without going back to prison. And going back to getting house arrest as a favor is what is reproduced in our justice system. And what is a reflection of that is the imposition of inspections or oversight measures that are very rigid, such as electronic monitoring, that comes from the presuppose that there will be the unfulfilling of the conditions of the penalty that are applied automatically without an analysis of the case in a concrete fashion, without a base that is individualized that shows why. For that person, there is a need of an electronic surveillance. And this automatic imposition of electronic monitoring as an appendix without concrete analysis sometimes reinforces stigma and deepens social vulnerabilities and economical vulnerabilities that these women already experienced even before prison. The life conditions of these mothers and pregnant women who are in house arrest because of all the lack of social measures and lack of access to employment and income, added to the many restrictions that are imposed, among them electronic monitoring, can sometimes even render impossible the right to house arrest, which is the exercise of the reason for the house arrest, which is the right to be a mother. We don't have to go far to find examples. Last month, there was a news report that was reproduced by Asmina magazine talking about the difficulties found by women who are waiting for trial or who are paying their sentence in house arrest with EM. And when you start reading, the first report is heartbreaking. A woman, she got into labor with her shackles in her leg. She could just go about 500 meters. She went. When she got to the hospital, she begged that they removed that shackle from her body. They removed everything except for the shackle, and the result is that this woman, while she was giving birth, she suffered an electric discharge. So a woman who is in labor had a shock while she was giving birth. This makes me recall another situation that I am obliged to mention. In 2017, a law came into force that prohibited women who were in labor or who just had a baby to be handcuffed. And this actually scares me and shames me to see that there is a country, that there was a need of a law prohibiting that a woman who is pregnant, is giving birth, be handcuffed. How invisible is a woman for society as well as for the prison and criminal system? And even after the law was published, we know that these women are still being handcuffed while they are in labor, and that they give birth with shackles, getting shocks into their bodies. How invisible is a woman to our society and to the prison and criminal system? So The first dysfunction, the practical dysfunction that I see in this case of house arrest with electronic monitoring comes from this distancing of the reality that many times is what bases the actors of the prisonal system. Afarones talks a lot about the bureaucratization we are obliged to follow that makes us judges follow behavior standards that are very strict, judging according to the convincing criteria that sometimes are too far from the reality of the vulnerable sectors. And as a result of this bureaucratization, an abyss of identity between the one who tries and the one who's tried rises. And from our offices, overwhelmed by so many things, sometimes we don't see and despise the way that most of our people live. And this indifference, this lack of knowledge of the realities we try produce a lot of problematic situations. There has to be a distinction between the different kinds of experiences and realities that are put for us to try. For example, the reality of a woman who is wealthy is different from most of the women who are in jail in Brazil. Black women, young women, poor women with low scholarity, who are the family provider, who do not have a support network, who live in terrible housing conditions, and with very little access to policies such as education and health. So even in those cases in which the right is recognized, we observe that there is still obstacles for an understanding of the complexities that are involved to ensure the exercise of motherhood and protection of childhood. And when you install an electronic equipment, you add other layers of obstacles and difficulties to the assurance of a dignified motherhood and adequate motherhood. Not to mention the stigma of having shackles on your body. Motherhood, especially to solo mothers, to providing mothers, the ones who are providers for the family, brings an extra concern, which is the maintenance of the family. House arrest, if it doesn't take into account the reality of precarization these families are subjugated to, of social forsakement, can worsen this problem. The placement of a shackle, as I said, is an extra layer in this process and enhances the obstacles to access to income. The stigma of a criminal with that equipment in their body, the limitation, the time restrictions, all of that could mean a loss of work opportunity and family maintenance, pushing these women sometimes to a worsen informal work scenario that could lead to reincidence. The practical problem of this system is the lack of clarity of the decisions that apply this measure. And here I would like to cite a survey from the Institute Terra, Trabalho e Cidadania that is very deep, which guided my study here in my preparation of this talk, which was produced to understand and systematize data on the challenges of the application of house arrest to the exercise of motherhood and protection of childhood. This research was developed from some interviews with women that are in jail or who are waiting for trial in house arrest, who describe their fears, their anguish, their fears, and their difficulties in the process. And the commonplace of the talks of these women, indigenous, black women from the periphery, was the feeling that they don't feel seen by the justice, that they don't feel that their stories are taken into account. So regardless of the experiences of each one of these women, all of them pointed to the lack of clarity of the judicial decision, as well as the lack of information about the conditions of fulfillment of these orders, which impose them two possibilities. Either they take risk, they take chance when they leave home to ensure their house maintenance, or be confined in the house, which leads and affects family dynamics and render motherhood impossible. And this lack of more clarity of the conditions or the areas of inclusion and exclusion of these shackles of what is prohibited or not, leads to the lack of structure of normatization, leads to more problem. The lingo used by justice, it doesn't help. What we see is that each magistrate has their own parameter to this system, establishing their own limits and their conditions. The limits established sometimes varies a lot, only so we can have an idea. It could vary from 250 to 5,000 meters. This is the area that they can circulate. So, in face of this universe of parameters, of conditions, and demands of this multiplicity that varies according to the understanding of the judge, it is up to that falls on the shoulders of a black woman. I am sure that there is an uncertainty regarding what is allowed or not, whether or not they need legal order to go to the supermarket, if they need or not tell the lawyer that they are going somewhere, if they can welcome, entertain people in their homes, if they can work. And this anguish and uncertainty is very understandable because the consequence of the non-fulfillment of the law can be the regress or the return to the prison establishment. And more than that, the report of the ITTC also makes a very important reservation. If we are to think about the vulnerable territories or the periphery, we need to consider the precariousness in the access to services and goods, and the movement of these women around the city so that they can run their errands and take care of their children ends up being the reality of their lives. These particularities in all their lives makes the limit of circulation imposed in the decisions even more complex. This is why it is very important that the areas of inclusion and the other measures that are imposed be determined according to the C&J in a more better system, paying attention to the individual characteristics of the people who are monitored and their needs. So there should be a psychological analysis so that we can render possible the conditions of fulfillment of the house arrest. And to close, the third dysfunction that I observe is a lack of articulation among the systems with the city halls and the assistance services. We observe a massified vision of electronic monitoring more as a security system and of control than as an instrument, than as a part of a penal system. What we notice is there is a lack of investment in sectors that could support in this process of inspection and support these women who are subject of house arrest. So I could be here spending the whole day talking about the theme, but my time is short. We still have a lot of contributions to be made by my colleagues, but I would like to close by recognizing the importance of house arrest as an advancement in comparison to incarceration, but recognizing this advancement also means becoming aware and taking different postures and measures regarding our attributions and functions. If by one hand this justice system cannot be pointed as the one and only responsible for so many issues, social issues that are experienced by women who are incarcerated, on the other hand, it cannot act indifferent to the realities it tries. So it is fundamental that the judiciary power, as it decides for house arrest with house monitoring, articulates their decision based on the other support network services and public policies of basic rights. Otherwise, house arrest could become another condition of aggravation in the context of inequality experienced by these women. I would like to finalize my talk with a phrase by Audre Lorde. I am not free so long as another woman is a prisoner, even though her chains are different from mine. Thank you very much.
I would just like to say thank you so much. It was worth the time to have left my activities in an agenda that was so complicated to come here in the CNF to hear the words that were amazing and so revested of good sense, the experience, and everything that Fernanda has said. So it is a great pride for me to see that we can have in the penal execution in all of these different areas of the judiciary power that work with this topic, that we have people that are so sensitive like Miss Fernanda. It is also necessary that we educate the society. Ms. Fernanda has said without half words that this prison is a prison. It doesn't matter if it's an open, semi-open, or closed regimen, but the society, unfortunately, doesn't see it this way. The society sees is it a great wonder that a person that is at home cannot complain about anything. Us judges, especially the ones from the high courts who have a great visibility, especially here in Brazil, we are criticized. And what our friends who are not from the legal area say is that we basically just are very good to the prisoners, that we want to do favors to these people. And with a society that has a lot of violence and crime, as if there would be more crime and more repression and more disrespect, as if that would improve the social condition. So it's very hard for a country that has the level of inequality that Brazil has, because this reflects in the house arrest. When someone thinks about house arrest, especially if this person doesn't belong to the social extracts that are the poorest or more marginalized ones, they imagine, this person is at home. So he thinks about his house, who has um, pool, TV, air conditioning, room for games. He doesn't know what it is to be at home in the periphery, which is worse than being in a cell, in a prison cell from the prison institution. It's as it happened in the pandemic when it comes to the lockdown. Lockdown was good for the high and medium class because they would stay at home, and many times their house cleaners would come in big subways to provide the basic services. I want more lockouts this way. Yes, like that, it's perfect. So we do not pay the price, and we even judge the other people who are going through this hell. So it is a very tough and delicate uh, subject, but I was really, really happy. I was delighted with Fernanda's lecture, and I say congratulations to her for talking about the social issue, the racial issue, and the gender issue that unfortunately is so huge in a country such as ours and countries under development as well, especially when it comes to the crimes related to drugs. This idea still persists in the majority of the population. This war against the crime and fighting against something that the women are most sacrificed in. More than 40% of the imprisoned men is because of the drugs, and They didn't have any position in leading organizations that truly have importance in this traffic. So they're paying for small roles. They are small fish. They are mules. And they're sacrificing an entire generation of children that don't have mothers. They don't have mothers or fathers, and they are obviously going to become part of the traffic. So I'm so sorry. I wasn't supposed to speak so much, but it's very difficult for us who work with the subject and not feel sensitive and compelled to say something, especially when we see such a beautiful and well exposed speech like Fernanda's. Given this consideration, now I would like to pass the floor to our second panelist, who is Roy Murillo, which is Roy Murillo Rodriguez, who is a master in fundamental rights by the University of Carlos III in Madrid in Spain. He's a professor, master in criminal sciences in Costa Rica, and it's an international consultant in Nicaragua, Peru, and El Salvador. And since 1998, he, just like Ms. Fernanda said, is a judge also of judge execution in Costa Rica. So it's a great pleasure to have you. You have 25 minutes to give your speech. Thank you so much. Thank you so much. Good afternoon, good morning, everyone. I do not speak Portuguese, but I promise to speak Portuguese next time. I am a horrible speaker. I speak too fast, and my ideas are usually disordinated. And I have a worst problem is that I hope that you can understand me. So I would like to already thank the translators because I know that they are going to have a hard time. I have this problem in my brain cortex, and I know that I speak too fast, and I know that that is terrible to the translators. So if you have any problems, please deal with me and not with the translators. Okay, so let's continue now. Thank you so much for the invitation. And I would just like to make a few reflections. They're very informal about the combination that Brazil and Costa Rica have in regards to the way that we deal with the electronic community and how this affects the possible resocialization issues and what would be the best way for us to guarantee
que
this
también tiene este
fidelity.
tipo de sanción. Bueno, efectivamente creo que esta combinación es como una especie de ornitorrinco jurídico, una cosa muy extraña, no técnicamente no correcta, ¿verdad? En otros países, por ejemplo en España, una es la pena de arresto domiciliar y otra es la pena de localización electrónica o permanente.
A house arrest or the permanent EM. And it shouldn't be a problem because that would be like a freedom type of arrest. And now we have other problems. This is at the light of the United Nations fulfillment of their trials of freedom deprivation and some other alternatives. But this word, imprisonment, is what generates a distortion in the logic that affect the way that we feel these sanctions. So there is an author, a Spanish author or a Spanish Argentinian author. I don't know if you know him, who has a focus in the legal sociology. He talks about the imprisonment, the penal control, and he says that this has to do with the conception of evaluating the right of people who have lack of freedom, but there should be a different way of thinking. He says, for example, that this ideology of visualizing people from the second or third category generates a few uh, problems regarding the imprisonment within the prison itself, the way that we manage the interpretation of the judges and the norms that regulate the norms, but it's still a very perverse topic in the idealization and the creation of norms that regulate the way that we have these punishments in the penal code. It also brings this ideology in Brazil and Costa Rica. There is this type of combination of house arrest and electronic monitoring. If we see these three spheres of the powers of the state, because the executive power talks about that, and there is a sentence that is controlled by the legal sphere, but in all of them we find this combination generating inconvenience in practice, because yesterday, yes, we talked about who controlled the electronic monitoring. Sometimes they are imprisonment officers. They should have a different mentality. After all, what is done in my country, for example, we got some professionals that were suffocated to control the house arrest with a very limited vision, because they understand that the system and the electronic monitoring is a modality of freedom privation, and that is completely wrong. We need to fight. We need to fight to leave this mentality of punishment and total control, because otherwise this is not going to work. So we need to work more and more in the different agencies in the system and have the obligation to guarantee that the alternative measures can be fulfilled, or else all of us will do really badly, because if the alternative ways of dealing with that is not self-controlled, supported, that they will be delegitimatized, and there will be a reinforcement of the prison. And always in any crisis, the prison is what leaves stronger and stronger. This thing of arresting people never gets weak. It gets stronger. There is enough vengeance to the population. And the other day, monitoring people is beautiful. It's something that we win in the lottery. It's like the opportunity of being able to frustrate people. But imagine if we accustom our bodies to have a strange device in your body that people discriminate to because you have it. And Jorge Amado used to say in Dona Florencia Seu Três Maridos that there is not a bad looking husband. I don't think that there is a bad looking type of crime, but every crime is a crime, and we shouldn't analyze it this way. There isn't a beautiful crime. Everything creates a harm. A famous rich person uh, doesn't go through this problem as much as the poor people do. They go through a fiscal fraud, and they continue in their network with doing what they had to do, and they don't disconnect. But if there are other types of people, we want them to learn and to go through hell to learn from their mistakes. So this is the logic that is behind this type of vision, and we need to reflect about that, because we need to understand that the monitoring should be a modality of like a freedom, but that is the only way that we can re-socialize this person and to reach our objective of re-socializing people in the best way, being able to go to the graduation of their children, to go to their at the house of their grandmother. Why should we restrict all of these possibilities? That is just a mechanism to help and to be able to have a project of life with freedom and responsibility. But if we just punish people and put them uh, in their house without a freedom to leave, they understand that as a punishment and they look for vengeance. So we need to control the freedom, but not to keep them from doing the basic things. So I don't know if I'm a good or a bad judge, but I am a weird judge. I recognize this. I have a different way of thinking, and the prison makes me afflicted. I leave the prison depressed, and I see that there are judges that are happy after they leave the prison, and as if they were doing a great job of keeping more and more people in prison, bringing this possibility to the way that they think is this way. And in Costa Rica, this position that I have is a privilege because it allows me to be the voice of a population that doesn't have voice. And from the experience that we have with the control and the punishment, we can generate and transmit a message that I find really important. The electronic monitoring without the right conditions is frustrating. I see that, for example, people say, remove that, and I prefer to go to prison. I don't want to keep this um, wrist device anymore. So it's something that we need to think about. Every time we think about this, it's important for us to have our own concept. But people are sometimes subject to this type of issue. And there is shame, for example. So people think there is not 100% good or 100% bad people. We need opportunities. This is not only the right for prisoners, it's a right from everyone, from all of the citizens. Sometimes we find ourselves very good, but think that those are problems from the bad people and that we're never going to be on the other side. And I am not sure of that. I'm not sure that we will never have this ankle device or this wrist device. I know cases of priests, of managers of banks that already went through this problem. Everyone has have the possibility of going to prison because there are just a few of them of us that have a defense system in our favor. But when people have their privacy removed from them or don't are not able to have their own freedom, in the future we can go through the same problem, and we need to think about what is fair and what is not fair, and we need our integrity to be respected as well. So with that, in our democracy we have a right for all and not for only some, because we talk about punishment and democracy. The regimen of this operation should be respected, and that is fundamental. It's a value that doesn't accept any other type of a different way of looking at the prisoner. Everyone has the same value as a human being. And those are the scars that keep going from one generation to the other, because in the democracy we have social responsibility. They don't think, I'm going to be a bad person now, I don't want to care about anyone else. That is not the way they think. I have many years of execution. I am a judge of execution because I have more than 20 years doing that. And I'm not going to continue putting people in prison and removing people from the streets to go to the prison. I know what happens in the street. I have already understood this situation. I'm not lying to you. So, for example, if we think about some experiences, because I started in Costa Rica when there was a reform and that incorporated this type of exemption, and I used to work in the capital, and there were many things regarding the way people used to do things in the country in the courtroom of the capital. And I started at first with this punishment mentality in a society mainly that used to complain about the fact that we would take so long to make our decision in the different cases that we would be dealing with, as if there was no solution in this trials. And I entered with this logic of imprisonment. If you made a mistake, the logic is putting them in prison right away. Instead of thinking, what happened? Why did it happen? Was it for depression? Oh, it was a violence. You have to go to prison right away. And the faster as possible, and all of the news and all of the journalists would talk about it all the time. So who are the people that fulfill these rules? Usually, in the rules of Tokyo, they have a different logic, and they talk about the possibility of initial hearing to explain to the person what are her rights, her obligations, how they feel. And I would even say that at the end, we are able to do that. And I am from the past, and the possibility of explaining how we do that in our countries, the judging, the judgment of the electronic sentencing, the majority without the access to technology, they can be supported in their own house. They think that they're going to be with the chicken, they're going to see their mother, they're going to have a, a person that is going to take care of them. Is going to be very humane, and the people will ask, how are you? And then the person will just have that device, but they will be assisted humanely. But that is not the logic. That is not the way that it happens. They think it's this way, but it's a sanction. And we need to inform these people that receive this type of sentencing what are the rights that they have, what they're going to be submitted to. There should be a modification to attend to the situations for them to develop their capacities and for them to be able to go through the sentencing. The person that has, for example, a health problem, there is a national council, and the idea seems to be really good in regards to this assistance. I would like to give a warm thank you to the people that are working, supporting these people. I would love to give a hug to all of these people. It's not as if it happens the way I would like to be, but there should be norms dictated by the state, and I should be obliged to respect the special rules. So these special rules can be related to the different procedures in the administration. For example, you have, for example, a way of controlling how many times the person can leave their house at what time. But in all of these cases, there is a report of discipline and to understand what is the problem that the person had, what happened in their house, why they had to leave their house. For when the person, when they are in the hearing, they can explain what happened. And a person, for example, that has a health problem or a drug problem, how are you going to do that? They should be in a center to be able to solve his issues. Um, if the person doesn't want that, it's okay, but At least we should give him an opportunity of choosing a way of solving this issue. But speaking about this ideology of the imprisonment and what is done and the norms that we have, there are very scarce opinions regarding the leaving home after a house arrest. And I saw that in the protocol and the resolution of the council, there was a law from Costa Rica that was created for the prisoner to leave home if he has work. The work doesn't go to the person. They don't go to the person's house and say, "Look, uh, I want you to work with me." No, they have to leave their house and they have to ask for this job and almost beg to be hired. So they have to go from Monday to Friday to different places to be able to find a job. And many times it's very difficult because of his past. So, even when they find a job, sometimes they don't have the capacity or the right to leave on vacation. So they only can be able to pay for their basic needs. So sometimes we need to take this into account. When the judge says, for example, look, I would love to go to Bahia or to go to the mountain, the judge needs to approve that. Uh, or the judge needs to say if they're going to stay at home all the way through or if they're going to be allowed to leave in a specific moment. So it is important that we take this into account. And for example, the school, their children can be in school vacation, and they need to see should they go with their children or not. Everyone is in the same household, and they are living together. It's not only the prisoner. So at least it is like this in my country. So sometimes they need to visit this prisoner because he cannot leave their house. So there are serious consequences to that. Like I said before, on Sundays, what do you do with your family? Do you go to the movies? Do you go to church? Do you go eat out? Do you go eat chicken outside in your city? So we have these different permissions. And a woman, Fernanda talked about this, the woman that has children. You can be in your house, you can leave to the neighborhood, take your children to school, or cook for them. So all of this is really important. For example, if a person is sick, when can this person go to the doctor, or when can the person buy something in the supermarket? Does this have any logic? Can it be justified? Sexuality, for example. The electronic monitoring should hinder the person from having an active sexual life. We need to think that sexuality is a natural right. It's part of the health, isn't it? So there are young people that live with their parents and that many times don't want to deal with this person anymore and that don't let them do anything. And they usually say, look, but I like to go out with my girlfriend. Give me a permission. Give me my right. And the right and law should think about that, should think about all of these different needs. And not only think about the freedom of the prisoner, but also the basic needs. This needs to be justified to guarantee this type of access to culture, to libraries, to freedom to have fun with their friends or something like that. So we shouldn't be violent when we think about this logic. We need to think about the sanctions, because sometimes the electronic device is, of course, we're not talking about the violent people. We cannot apply that to the people who have been violent. So the people that use these devices usually in the cases of people that are not violent. We, I'm not the only one saying that, because it's not about what I think or not think. These are the rules of Tokyo. They are special needs, but they not exclude Nelson Mandela's rule. And when the person can't find a job outside or outside of his cell, does he have right to the sun or physical exercises? And if the way that we monitor the person um, have 1 hour of exercise right or sun right, of course that we're not going to let the person out to at 8 and at 9 for example at night, because to do exercises, because then he can find people who sell drugs. But we need to guarantee rights and to understand them as human beings just like you and me, that are trying to reinsert themselves in the society. Thank you so much. We have just heard the beautiful speech from Roy Murillo. He has given us this funny comparison of house arrest and electronic monitoring as if it was an elephant in the room. It is a mammal and it's a weird animal, but at the end of the day, like he said, the electronic monitoring, it should follow a logic that is distinct from imprisonment. Imprisonment is one thing, and electronic monitoring is to control the freedom without allowing the person to leave their house to do anything. The basic needs, for example, the mothers with their children, to go to the park, to take them to school, for example, or this person who couldn't eat something outside of his home. It was always something that he couldn't do because he couldn't leave his house. So those are things that we need to consider, and we need to alter this mentality of the people that are operating these mechanisms, so as to have a different mindset regarding imprisonment. So we have an entire systematic here that is distinct, and if it doesn't obey to a new logic, it is going to end up having a violation of the human rights of these people. And the more vulnerable these people are, the more they are going to be harmed and prejudiced. And this topic that was transmitted to me, I'm going to give the floor back to the panelists so that they can give their final considerations regarding what each one have said for 5 more minutes, starting by Ms. Fernanda.
Well, can you hear me? Well, I would just like to thank once again for the invitation. I know time has run by, and I also added a few more minutes to my talk. So I would like to say that I'm very grateful for being here today, sitting with my panel colleagues. I hope I have contributed, and I also hope that until the end of this event, we can think about solutions and alternatives in face of this human scenario that we have ahead of us. Thank you very much. Thank you, Dr. Fernanda. I'd also like to grant the floor to Mr. Roy Murillo, 5 minutes for his final remarks. Can you hear me? I would just like to take this time to mention two things that I forgot to mention. One couple from a marginal neighborhood, and they they can't work. The girl needs a special milk, and so they decide to steal a phone. They had never stolen before, and they were arrested for the first time. So the court replaces the sentence, but does not allow them to go out. The execution takes time, so the expedient is what decided that should be done. In other words, that the law has a problem, that any permission needs to be authorized by the judge. And this is terrible because the solution is not immediate. You need to give time for the parties to speak. And these children didn't have anything to eat. The child who was 2 years old, the court, we would call the administration would say, no, it's not up to us. So he got a job downtown, and so he started to work, and then he went to the police and said, I am going to work in this commercial center. So because even though he communicated that he was going to leave, that he was going to go somewhere else, he was still found as no fulfillment of the observing the law. So the case came to court. So what should this father do? Not feed their family so that they cannot be sanctioned? This case came to me, and I looked at the system and said, he is being a good father. It's the system that is not operating well, and the prosecutor worked very badly. In the initial hearing, we had a hearing, we did that, and so when I started talking, I said, sir, please tell me, can you do some sports so that you can lower your anxiety? When I started to talk to the man he started crying. He didn't stop crying. And I said, sir, I'm not fighting with you. What's going on? And I didn't insult you. I didn't do any sort of reproval. He said, I've been in jail for 2 years in my house. There is no wall. I filled all the wall with tiles, and now you tell me that I can do that. And I start to think about all the things that I failed to do. A man crying, how can I tell you? A man without any consolation. This is what we do. This is the logic that I would like to leave to you. Thank you very much. Well, because of the time that is running late, and also because I believe that any issues that the audience may have to our speakers, you may send your questions via the organization of the event. I would like to once again reassure my joy upon being invited to this gathering. So through Judge Lanfredi, I would like to say that it's a great joy for me. It was an amazing afternoon to see so many people here, like Professor Somasso and Professor Roy, say that's not only in Brazil but all over Latin America. We are all fighting for the same goals. Thank you very much. I give the floor back to the MC. Ladies and gentlemen, we'd like to thank for these talks, and we are going to continue in a few minutes.
Em continuidade à programação,
To continue with today's program, the National Council, through the Doing Justice program, developed a lot of publications via electronic modes. We have manuals, guides, and practical guides observed from the action of this program. The publications are accessible via a QR code available on the screen, as well as in your booklet that you, ladies and gentlemen, can find at the entrance of this auditorium. In addition, in an effort of internationalization and fusion of technical knowledge without borders, the Doing Justice program is launching in this conference the main products about electronic monitoring in English and in Spanish. They are models for people's management, information for security network, for social security, for the justice system. Finally, you can also find, ladies and gentlemen, the translation into English and Spanish of Resolution 412 of the National Council of Justice, which is the landmark on guidelines to the monitoring of people. You can access the product via QR code and in the booklet of the event. To present the panel, the place of social monitoring. Social protection in electronic monitoring, we invite the coordinator of the social executive system, Ms. Carolina Tassara, and as speakers, the judge of the Court of Law of the State of Mato Grosso, Geraldo Fidelis, the national coordinator of electronic monitoring of the National Secretary of Penal Police Policies, Manuel Silva Morim, Mr. Liam Martin, Professor of Criminology of New Zealand, and the President of the Association Mais Liberdade, Mr. Sandro Augusto Loham. We hand the floor to Dr. Carolina Tassara. Good afternoon, ladies and gentlemen. Good afternoon, ladies and gentlemen. Following the good example of my colleague Salomon, I'm going to start describing myself. My name is Carolina Tassara. I'm 41 years old. I'm a white woman. My hair is shoulder length. I am dressing purple blazer and green blouse. I would like to start this event on social protection and EM. I would like to greet our speakers, Dr. Liam Mart, Ms. Manuela Morim, Dr. Geraldo Fidelis, and Mr. Sandro Naumann. Also, I would like to greet all of you who are in the audience and also those of you via YouTube. For us, it's an honor to welcome each one of you in this very important event that is being promoted by the National Council of Justice. To start the debates, it is important to highlight that the criminal justice system of Brazil grants to social protection an important role in the electronic monitoring of people. Monitoring measures should not be limited only to freedom restriction, but also to seek to promote some possible social reintegration of the person who's being monitored, aiming to ensure a humanized approach to the needs of each person who's being monitored. Social protection reviews as being indispensable, geared towards providing support to the overcoming of difficulties and favoring the conditions of reinsertion to society in a sustainable and healthy fashion. Social protection should involve, therefore, access to health service, education, capacity building, adequate housing, social and psycho support according to the needs of people. In this aspect, social protection is related with prevention of violation of rights and the assurance of respect to human dignity. It is essential that the monitored people be treated equally and in a fair fashion and have their rights preserved, which we have seen along this period of the conference, which is a big challenge. And that implies in ensuring that the monitoring devices be used proportionately, that they are not imposed, that conditions be not imposed that are inadequate and injustifiable, as explained by Dr. James in the morning. That the collected data be handled with responsibility, ensuring the privacy as well as the security and safety of personal information. With these brief remarks, I'm going to hand the floor to Dr. Leon Mark, who I'm going to introduce now. Dr. Leon Mark is a researcher of Victoria University of Wellington, New Zealand, focusing on incarceration and alternative to prison. In his field work in a house in Boston, he published the book Halfway House, Prison Reentry and the Shadow of Prison Care via the New York University Press. Currently, he's developing research on the increase of EM in New Zealand. Professor Liam, you have 20 minutes for your talk. The floor is yours.
Hola. My colleague Eon this morning told a lovely story about the overlap between the Romanian language and Portuguese, the way they just fit together so naturally. Unfortunately, we don't have the same thing with my New Zealand English. I have only 2 words in Portuguese. I have used one already. I will use my second Portuguese word to say obrigado to especially Isabella for her hard work organizing the event and getting me here. Also to Luciana, who picked me up at the airport, Zuleika, who's helped me in many ways over the last month or so. So obrigado. The ideas I'm going to share today are based on work I've been doing on the growth of electronic monitoring in New Zealand. As far as I can tell, New Zealand now has the highest level of electronic monitoring per capita in the world. We're a small country, about 5 million people in total, but we have almost as many people now on electronic monitoring as we do in our prisons. We have 6,500 people on electronic monitoring around 8,200 in our prisons. One of the questions I am really interested in thinking through is how we might think about the connection between the growth of electronic monitoring in New Zealand, but also in Brazil, and the United States and other places too, the connection between that and the growth of human tracking in everyday life. We live in what some have called the age of surveillance capitalism, where some of the most profitable companies on earth, like Google and Facebook, have business models based fundamentally on mass surveillance and location tracking. A world where it seems almost everyone and everything is tracked and monitored all the time. If you use your smartphone to purchase a package online, you can follow the item through to delivery and will likely have your own location tracked in the process, along with other intimate details about your life, your desires, your experience, and so on. One of the photos on there shows me ordering an Uber to the hotel. I'm staying at the Royal Tulip, a lovely hotel. Thank you, United Nations. Obrigado again. When you order an Uber, you watch the car travel in real time, in space, on the road, to your location where you are. Everything's located. There was a mention earlier today about wife tracking in Saudi Arabia. You know, I had a conversation over lunch. Anthea was talking about the kind of routine ways in which parents are now tracking their children's location. This kind of tracking is absolutely routine. So in this world where nearly everyone and everything is tracked and monitored all the time, how do we think about the growth of electronic monitoring in criminal justice? In this panel, we're engaging in a discussion about social protection in electronic monitoring, and I want to argue that if we want to have a serious discussion about rights and protections in electronic monitoring, we need to really think about the connections with other forms of location tracking and mass surveillance that are utterly normal now, built into almost all new mobile phone technologies. So that's what I'm going to do for quite a bit of my talk, is work through some connections. I'm developing these ideas. They're in development. One of the concepts I've been thinking through is the idea of an incarceration telecommunications nexus, a connection between our phone technology and new kinds of incarceration, you know, unexpected connections, ones that aren't obvious on the surface. So I'm going to share now 5 connections that I've learned over the last couple of years researching electronic monitoring in New Zealand. Connection 1. Tracking devices in criminal justice are assembled from component parts designed for smartphones. The photo there shows one is the TD4i. This is the main tracking device used by the company Attenti in New Zealand. It's an industry standard GPS tracking device. Next to it are some Samsung smartphones. At first glance, these seem like totally different kinds of objects. They actually have striking similarities. In fact, the typical GPS tracking device, the TD4i, along with others, are assembled from component parts designed for smartphones. The microprocessors, circuit boards, batteries, Bluetooth chips, GPS antenna, Wi-Fi antenna. These things are not made for criminal justice tracking. They're made for smartphones. And then electronic monitoring companies reassemble them into devices for electronic monitoring. I think it makes sense for us to think of them as some kind of variation on the smartphone, maybe a mutation of the smartphone. Connection number 2. These devices use the very same GPS satellites for location tracking. GPS technology was developed by the US military, and the earliest applications to human tracking were in policing. It wasn't electronic monitoring, it was like putting GPS tracking devices on the cars of suspects, for example. These days, these technologies have migrated from the military to policing, now all of our smartphones. There are 32 GPS satellites orbiting the Earth. Each is sending their exact location back to Earth, continuously at the speed of light. For a receiving device to find the longitude, latitude, and altitude of any location, it needs signals from 3 separate satellites, with a 4th used to make technical corrections. That process is illustrated in one of the photos up on the slide there. This method of tracking is fundamentally the same, whether the location is being tracked in electronic monitoring or when you're ordering an Uber to pick you up from the hotel. Connection 3. I was recently able to interview Robert Gables, the man generally cited as inventing electronic monitoring in the 1960s. He's 89 now, he lives in Berkeley. He generously hosted me at his house and talked to me about inventing electronic monitoring. In these experiments, one of their key technical challenges was coverage. They had an antenna which they put up on a church steeple, and it allowed them to monitor within about a 5-block radius. So as soon as people leave that 5 blocks, they don't know where they are anymore. You know, it's a small level of coverage, and it's basically impossible to expand because, you know, you're going to have to hang these antenna. You know, they've got one above the church, but, you know, what are you going to build a network of antennas? No, you can't do that. It's impossible to scale. But the problem of coverage has been solved in the time since by the network of cellular towers that now crisscross all of our neighborhoods. Now you don't need to put up your own communication network. You tap into the existing infrastructure. And tracking devices in criminal justice, like smartphones, are fitted with SIM cards to access this communication network. I tell you, doing this research has really made me notice the cell towers. I had never looked at them before. I'd never noticed them. That's a photo of a cellular tower just around the corner from my house in New Zealand. And I've walked around the neighborhood and taken photos and looked at them. They crisscross our world. You know, this is how the communication happens. This is critical telecommunications infrastructure, also central to the system of electronic monitoring. The way we do electronic monitoring now would be impossible without it. I can't see the time. Ten more? Oh, look at that. 10 more minutes. There, I'm doing well. We've got plenty of time. Talking with Robert Gables about his experiments with electronic monitoring in the 1960s, it also became quickly apparent that they didn't really know where people were, very precisely at all. Part of the problem was they were using military equipment designed for missile tracking. That early go at designing electronic monitoring, they literally went to a military surplus shop and they bought the stuff. It was designed for missile tracking and they turned it into an electronic monitoring system for humans. Part of the problem and part of the reason they didn't really know where people were, it didn't seem like to me talking to them, to be honest, was that they visualized location on a radar. You know, it's how I picture a radar. You can see the picture there. That's the actual, that's Robert Gables' brother. They're twin brothers. They designed the tech together. Doesn't that look like how you would track a submarine or a missile or whatever, you know? But it's not plotted onto life. It's not plotted onto streets and addresses. So you can have a dot on there, but what does that mean? What does it tell you? This has changed dramatically with the development of new mapping technologies, and these days, you just use Google Maps. The same Google Maps that many of us use every day to visit friends and family, you know, see friends, find the restaurant, especially when we're traveling in a new place, always going to Google Maps. Well, the electronic monitoring companies are also using Google Maps. That other picture on the slide there is from Attenti, one of the world's main electronic monitoring companies. Their promotional material, their advertising material, and it specifically talks about how their EM Manager software visualizes location data using Google Maps. Oopsie daisy. This one, I'm still figuring out my language for thinking it through. This connection, but let me get through it as best as I can. Tracking device, this is our 5th connection now. Tracking devices in criminal justice and smartphones rely on the same data storage infrastructure. This infrastructure is foundational to electronic monitoring and to surveillance capitalism more broadly. If you want to track everything and everyone all the time, you need a lot of data storage, you know? Data storage on a once unimaginable scale. Our existing language for thinking about this is flawed. The cloud, for example, as if the data floats in the air like the clouds. Data is physical. Data is big. The data storage servers are massive. One way to think about the scale of these operations is to think about the electricity they use. In the country of Ireland and the UK, server farms use 15% of all electricity in the country. And this is forecast to increase to 30% by 2030. These server farms are often owned by large surveillance capitalists. The photo behind me shows a server farm in Iowa owned by Google. which is one of the main owners and builders of data storage server farms, Google. Microsoft, Amazon, and Google. Massive investments in data storage facilities, and they're investing massively in building them in New Zealand right now. Amazon recently committed $7.5 billion to building data storage infrastructure in the small Pacific Island nation of New Zealand. $7.5 billion. These are enormous investments. They are enormous investments that, support data gathering of all kinds, but they are also critical to electronic monitoring, So how do we start to think about the connections between electronic monitoring and this booming data storage industry? One of the things I'm thinking about is, so we've got Google, Amazon, Microsoft investing massively in data storage in New Zealand. How does that relate to our apparently us being a world front runner in electronic monitoring? To me, those two things seem connected, but I'm trying to think about how do we, conceptualize how they are connected. Still can't see the time, but can I get a time update, Carol? 5 minutes, thank you. I'm just going to put the time on my clock so I can see it. All right. Okay, my next slide just summarizes the connections. So that's the 5 connections that we talked about. The argument... Oh, there we go. Thank you. Obrigado. The argument that I'm developing is that we need to explore the expansion of electronic monitoring and criminal justice in New Zealand, where I work, but also I think in the US and Brazil and other places, although I feel less sure of those connections. In relation to the rise of surveillance capitalism. One thing, so, that means like the connection to the forms of human tracking that we're all, enmeshed in. But to talk about it in terms of surveillance capitalism is also a pointer to follow the money, to pay attention to the business interests involved. Electronic monitoring is an area of justice reform. It's at the same time an area of investment and profit making. It is a fundamentally privatized system. States don't produce electronic monitoring technology. This is done by the private sector, most obviously by specialist electronic monitoring companies like Attenti, BI, Spacecom, and more. But what might it mean to think about Google as an electronic monitoring company? They provide the mapping software, the data storage servers, maybe, and so on. Or how do we think about the role of the big telecommunications companies that own the cellular towers? Might these be electronic monitoring companies? I think thinking about surveillance capitalism encourages us to open up these kinds of questions about the broader business interests involved. I've been talking about the similarities, but let me now turn to a key difference between electronic monitoring and other kinds of human tracking. What is unique about electronic monitoring is the way that it converts the familiar technologies of location tracking built into our smartphones into tools of incarceration, what many call e-carceration now. I don't know how this translates, but incarceration as in the prison, e-carceration as in digitally created prison, The tracking device might resemble a smartphone in some ways, but it's clamped to the human body. It's a coercive device. Unlike our smartphones, which attempts to draw us in, the electronic monitoring device is coercive, clamped on, unremovable. It's programmed to create invisible walls that trigger alerts if the person attempts to escape. In New Zealand, the probation officer shows up with a map, probably Google Maps. The boundaries drawn on the map, don't leave those. There's your walls. The walls can be raised or removed at different times, allowing people to exit during the day, at home under curfew at night, for example. There's various levels of restriction. You know, some people might only be locked down a few hours a day. But to talk of these as practices of e-carceration is to draw attention to their role in confinement. Usually confinement to a particular house, but increasingly movement outside is also restricted by programming exclusion zones around schools, parks, and neighborhoods. These practices create new geographies of incarceration that don't rely on prisons. And in New Zealand, where I work, already rival the scale of traditional imprisonment. I can see my time's about to end. I'll just take 1 minute to say that unlike smartphone tracking, which is broad, largely indiscriminate, you know, we're all kind of part of, when it comes to e-carceration, the old inequalities come to the fore, as has been talked about today on other panels. In New Zealand, a former British colony, a settler colony, Indigenous Māori are around half of those subject to electronic monitoring, but only 16% of the general population. This mirrors almost exactly the disproportionality in traditional imprisonment. And as we debate the potential harms and dangers of EM, I think we need to keep these inequalities squarely in mind. I had some, you know, I was going to try to link back to the themes around of the panel around social protection, and just to really flag that these are fundamentally untransparent systems. You know, they're privatized, so these private companies, it's very hard to figure out what they even do a lot of the time. You know, where is the data stored? Who has access to it? Under what circumstances? You know, these are difficult questions to answer, even though they are quite fundamental. Oh, I think I can conclude there. Thank you for having me. I really appreciate the opportunity to gather with you. You know, I was going to develop a bit more around the lack of transparency. And, you know, I think basic empirical questions about how the system operates are very difficult to answer. So I really just value and prize these kind of opportunities to gather with others, to exchange ideas, to educate each other. So thank you for having me. Obrigado.
Professor Liam, pela sua exposição. Não sei se agora foi. Muito obrigada.
For your talk, for your brilliant talk. In fact, it's very rich, this opportunity to have this exchange and from your reality in New Zealand, but also bringing very important issues that actually is dear to us all, raising important points of concern. And in this moment in which electronic monitoring is taking space all over the globe, so I believe that it was very important to hear you talk, as it's been along the whole seminar, these points of attention with such sensitive and present and real issues, and the importance of being watchful. To continue with our program, I'm going to hand the floor now to Dr. Manuela Morim, who has a degree in arts via the Federal University of Bahia, in psychology via the Federal University of Bahia as well. She has a master's from the Federal University of Mato Grosso do Sul, and her research line is studies of critical theories of the society. She is a public servant. She's a psychologist with expertise in penal psychology linked to SINAPAIN and public security, where she has been working since 2014. Currently, she is the National Coordinator of Electronic Monitoring of SINAPAIN. Dr. Manuela, the floor is yours. You have 20 minutes, and welcome here.
Okay, the floor is open here for me. Good afternoon, everyone. I would like to greet everyone here present with us, and I extend my greetings to everyone that is watching us online as well. So let me see if I can get the pointer to have autonomy in my slides. Let me see if I can pass the slides here. Senapeng. It's in the email of the ceremonial. We have even tested in the earlier. Technology sometimes fails. I don't know why it's not opening. Considering the small technological issue, can you open it here? So I'm going to pass the floor to the General Director. Before we continue doing this, I'm going to invert the order and pass the floor to Mr. Geraldo. This way we can continue with the interventions. Geraldo Fidelis is graduated by the Federal University of Mato Grosso, and he's also an expert of infam, and he's also has a master's degree in the Federal University of Mato Grosso. He is a judge in the Justice Court of Mato Grosso, and since 2003 he works with the criminal execution. Welcome, Mr. Geraldo. You have the floor for 20 minutes. Thank you so much. The president of the table, Caroline Teixeira. Good afternoon, everyone, and everyone that is watching us online in CNJ and YouTube. So, I would like to thank everyone very much with Penudi and everyone else, and also Isabelle Pimenta, my teacher, and Zuleika. Thank you so much for the invitation. And in general, friends of mine from Mato Grosso, Luis Geraldo Santana da Fred, who is a coordinator of DMF here in CNJ. And so I was asked a few questions about what is electronic monitoring, what it serves for, and also stigmatization, imprisonment. It seems like a journalist type of question, but I'm going to add two more. I was talking to some friends about the electronic monitoring. Is it an alternative to freedom or to imprisonment? Is it difficult to enter in the prison or in the free environment? So for Foucault, the prison is the control of the body of the person, of the prisoner. It gives discipline to its body, giving a way to be easier for him to work in the society. Therefore, he has based in the project of Panoptibentum. I have even put a picture here of a panoptical bento to have an ideal prison to be able to correct, and it's panoptical, has this architectonic circular structure that allows that they are exposed in an observatory in the center, and the person that is going to be in charge can observe every prisoner without them knowing that they're being observed. That and in that exact moment, they are surveilled, but they don't know if they're being so. But they feel this permanent surveillance. So for them, everything is being written down in their document. So even if they're not being surveilled, they feel this way. So panoptical is, in the speech of Foucault, the perfection of the power because it domains constantly, even when it's not being done with the technological moment. We have the panoptical every day because we have cameras observing us all the time. And those are the cameras that surveil our every move through satellite control. Every step that we take is analyzed by people that we don't know. However, they exercise their authority in the controlled subject that is being monitored, but that educates itself and doesn't see it as being bad. It is crazy how the panoptism and the electronic monitoring are so similar. And there is this physical feeling of permanent surveillance of every step we take. Besides that, we know the good that was mentioned here, the stigmas that were done by the electronic devices, and this allows us to have another possibility of understanding the imprisonment to hinder any type of escapes and areas of exclusion. So we oppress the prisoner under the regimen of going back to the prison. So this fear of being punished and the fear that they have is huge. And who are the people that are being monitored? This was really well exploited before, so I'm not going to enter into details about this. But everyone knows that it's that situation where the person, the young people, the poor people, the people that are in the margin of the society are monitored. But the truth is, this means that this is the incarceration of the undesirable. And this creates a reboot type or a type of increase of stigmas that are provided by the prisons. And it makes it difficult to reinsert people in society, people that are deprived of their freedom. They are seen as people that cannot live in society. They should permanently be away from the society. And the best hypothesis, between quotes, the benefit of the electronic monitoring can be seen this way for the majority of the people. And this conclusion is what foments this culture of the fear. Living in the big cities makes us control, and Vitor Neiva and many other authors have said that there was a paradox of the imprisonment in Brazil. There is a demand of decrease of punishment for severe cases, but it recognizes clearly how the imprisonment of the different areas had perverse factors that contributed to the different areas of Brazil. So, in Nelson Arruda's case, there is a case of non-freedom, and the suspension of certain groups and individuals through the inequalities act as a social control. My friend and professor Ingrid Pimenta and have mentioned the following. The services of monitoring, of electronic monitoring, guarantees from the scale the control of a delinquent that is being monitored. Everything is seen as some individuals that should have been imprisoned, but now this constant monitoring can be as if they were being threatened to go back to prison. They close the codes. So this makes the strategy of repression even higher. That makes the legal inequalities bigger, even so. And the recrudescence of the structural racism and also the mass imprisonment is even higher. So we try to give this answers to the main population, the segregation and the imprisonment in Brazil. It's as if there was a death penalty or even other types of violence against the prisoners. The truth is, it's fundamental that we demystify that the person that loses their freedom, they are not only bad people or assassins or any type of criminals. The truth is, this provokes physical, social, and psychological damages, making the social reinsertion even more difficult. I am a judge of the execution in Cuiabá state, and we apply in the majority of the country here in Brazil different solutions for the semi-open regimen. The progression from the closed to the semi-open regimen in Brazil is not done most of the times because of economics. This measurement makes the regimen increase the vulnerabilities in the federal constitution and this discussion of the penal code. So what can happen in the future is that this person that is being monitored, if she is close to a store and the store has a problem, they can feel that this technology is being used against the human beings, and there should be an investigation that would be open for a person that didn't even commit the crime. So the electronic monitoring needs to assure the rights of the people that are being monitored. But the touchstone, philosopher's stone of this issue is for people that look at this as if it was a benefit. This cannot exist. Being at your own house for the house arrest doesn't mean that you are not doing what you need to do or that you are being in lack of freedom. And people need to understand that. Isabella Pimenta once again has mentioned, between quotes, that the electronic monitoring is conceived as a policy of prevention based on the control of the corpus, the people that have already been inserted in the criminalization sphere. And this reproduces significant impact to the people that are imposed the electronic monitoring, implying a bigger difficulty to build their trajectories, and they end up being attracted more and more by the procedures of the central or by the modalities that are done by the police as a whole, or even the electronic monitoring systems. Therefore, it's important for us to apply different measures for the electronic monitoring systems. So, the EM and open regimen, this access control can characterize the lack use, the bad use of the resources of the state, and even worse when there is a fee that people need to pay for fulfilling their open regimen. They this is a problem because the majority of the times they don't even have money to feed, so they don't have even a way of paying this fee. And what is worse can get even worse because there are states where they have already legislated on something that is unbelievable. They create unconstitutional norms of charges as if it was a benefit for them. And the decision making, when we I don't know my time as well. Can you help me? Okay. When we apply the electronic monitoring, the judge needs to analyze the specificities of the case because the application of the device needs to be faced as an exceptional measurement or an alternative to the provisory imprisonment. This means that we shouldn't apply that as an additional measurement for the control of the accused that would already be responding to the process in freedom. And also, because of the subsidiary measurements, they need to be taken into account. This EM in these situations, they need to be applied in a very residual manner and only as fact to avoid the provisory imprisonment. And it's a need in the cases where, one, the person is accused of the maximum superior provisory imprisonment, or when they are and second, when they are judged in the penal code, and third, when the person has an urgency that involves children, adolescent, or women's harassment or sexual harassment, when there is no other way of punishing this person immediately. So this can only be applied when we verify and fundamented the need of surveillance of the person that is being investigated after the demonstration of the inapplicability of the provisory freedom, with or without bail, and the insufficiency of the different provisory precautionary measures, considering the state of innocence of the person. In the same way, the electronic monitoring can only be applied when we are able to see the situation of the person that is being investigated and the objectives related to the crime. Above all, when there is a disproportionality in regards to the EM, where there is a condemnation, but there is no imprisonment at that moment. And also, the EM should also evaluate the dignity and the normality of the prison, the essential needs for us to re-signify the collective and individual rights. So we should always think about the dignity and the people's freedom through the social justice, guaranteeing the health conditions and all of the things that we do. So in this use and the individual monitoring, the application of the electronic measures should not have a degrading, a disrespectful type of activity to the fundamental rights and the perpetuation of stereotypes. So behind this, we should also, the monitored areas should not be submitted to harmful, inhuman type of treatment. We should take into account the psychological and the other type of restrictions that were done before. Besides that, the measurement should have an established deadline, as well as we should have a re-examine of the need. So this perpetuation cannot lead to worsening of the principles. And also, according to CNPC of 2007, the measures should be applied in the knowledge area and also in moments that it's not adequate. And CNJ, at this moment, In the precautionary measure, they do not accept the monetary electronic measures for determined deadlines or a very more than 6 months. That is something that CNJ says. And continuing, the regulation of the proposals can be considered as an element to review the EM that was applied, revealing the excessive control that can be substituted by other self-responsibilities in the established activities and the social inclusion. CNJ 235 of 2015, and they should attain to the judicial measure, assuring that there is not a huge harm to the normal routine of the person that is being monitored. And it should also not interfere or do that in the least impactful way of the person that is being monitored, in the activities of the person that is being monitored. To apply the EM, it's fundamental that the centrals of electronic monitoring and depending on the flow of each one of the states could have a physical structure and multidisciplinary team that is composed by a social assistant, a psychologist, and a lawyer to accompany the people that are being monitored. Many of these cases are reflected as a hearing of justification with requests of the regimen, and all of this can be solved in a social inclusion. In this case of the social reinsertion, it needs to be an embracement of the citizen. Everyone knows that without the accompany of the judicial spheres, they do not offer equity to the majority of the cases. There are rules, and they could be attended by multi-disciplinary teams in a qualified manner. There could be adjustments that could be done for the social and health networks that could prevent or even make the crimes decrease even more, especially in the case of the drug users, reducing the damages that are in the states that have this history in the different activities. Isabella Pimenta once again says, and others, remembering Foucault, the repression in the way that is done is giving a new way of controlling the stigmatization that we have. And so it is a new situation, and especially in this vision of the monitoring, the perspectives, and the punishment of this area, in the penal code as a whole. In fact, for those who could question eventually that if in this moment the ones that were here did not have the look at the victims of the crimes that took people to be monitored and to be arrested, I need to say the following. We have only talked about the victims. Hundreds and thousands of victims that will continue existing if we don't cut the cycle and help in the people that are in the prisons. So we need to continue doing this. And for that, I think that my time is up. I only have 30 seconds. So the state needs to be present in the social attention of these people with the articulation of the different stakeholders. My friends from Mato Grosso are here from the executive power, and we have this great articulation between the legislative, judicial, and executive power. So we align methodologies, strategies, and expand the services so that we really can face the incarceration, imprisonment, to decrease the damages, vulnerabilities to those who are in EM, under the EM. And to finish with all of my friends here and judges that analyze each case with its particularity, with its profile, in a unified manner, with the copy and paste, because we're almost like computers. We are not computers, we are human beings. We, I would like to talk about Charlie Chaplin's quote. We are not machines, we are human beings. And it's with the love of our souls that we shouldn't hate. The ones that we hate is because we are not loved, and we are human beings, we love.
Thank you, Dr. Geraldo, for your amazing lecture. In fact, it is a great opportunity and also important to have people like you and Dr. Fernando Orsomaso calling attention of the judiciary power and all of us to the importance of the non-banalization of the EM. We followed the hearings, and Isabella was with me, and we had 20 some people presented there, and all of the people out of all the people who were arrested, either bail was applied or people were monitored. Many people were monitored, and that made me really perplexed, because including the way how the form was communicated. I mean, the idea that was communicated was it was given a benefit, and because there wasn't yet the service to people who are under custody or a rightful network to follow these monitoring and to make clear the conditions that were determined. So the judge informs the decision but doesn't inform how it should be followed. And when the judge says, I mean, when the Professor Liam says that the judge shows how far that person could go, that is shocking to me, because we don't do that, and it's so clear, because if you cannot go certain spaces, you must have clarity of where you can go. That only shows the size of the challenges we have in Brazil and how important it is, the social protection network. So it is very important that after this beautiful presentation made by Dr. Geraldo, it's fitting that we hear Dr. Emanuela, that I have already introduced, but in synthesis, she is our National Coordinator of Electronic Monitoring from Sendapen, and she will bring important important updates of these issues that concern us every day. Dr. Manuela, you have 20 minutes. Hello? Today's not my lucky day. So everyone, good afternoon, ladies and gentlemen. It is with great joy that I represent the National Secretary of Penal Policies. In this first slide I brought to you the new organogram of the Secretary, and I would like to say that this change happened from the decree number 11-348 of January 1st, 2023, and it's a change that doesn't happen only on paper. The Secretary has changed. In the beginning we were the National Penitentiary System, and today we are National Secretary of Penal Policies. We have a national coordinator, And we also have now the National Coordination of Electronic Monitoring, which is under my responsibility to represent. So we have many studies. We have our basic baseline Foucault telling us that prison never fulfilled the ideals that it was supposed to. So this organogram shows exactly that, many years that show the inefficacy of prison. But the fact that we have penal alternatives, especially EM, cannot take from us, take us out of a critical position that this represents. We need to look at beyond the apparent reality. We know that technology is very seducing and enticing. Technology seduces, but it doesn't solve the social issues, all of the social issues. I think that this is very clear in all of the talks and studies that we have seen here today. When monitoring is applied in a vague fashion, the possibilities of low efficacy are high. In other words, the possibilities that technology will not work is high. So we cannot just shackle up people and let them go back to the same vulnerable situation that brought them to jail in the first place. This is the first reflection that we must make. Monitoring should not be used vaguely. With that in mind, the National Coordination has developed a central objective. We need to ensure the application of this measure in all of the Brazilian territory, ensuring effective work of the centrals and their operators with the support of the multidisciplinary teams, ensuring the rights of these people in these assistance, in the services, and most importantly, in a way that it's possible to do the individualization of the penalty. When we look at LAPI, the rights to school and labor are clear. And it really scares me to know that in social measures, these people don't study, they don't do anything. The state does not have any data about it. This is really scary. Is the state taking responsibility out of their shoulders and throwing it in the shoulders of the person? Like, you've committed a crime, now you're responsible for your life. These are important issues that we need to dialogue about. Oh, damn, it's off. I've brought some data. We don't have a lot of data, this has been said. We have very little data in regard to the population that is monitored. But we have the data from CISDEPEN that talks about the whole volume of people monitored in Brazil. What do we see? We see that penal execution is in the core of EM, representing 70% of this audience. In the ideals of the EM, the idea is that people did not have any contact with jail, so that they could avoid the effects of imprisonment. In that way, they wouldn't have the moral, physical, and especially psychological damages caused by prison. But this is not what we observe. In fact, EM is concentrated on penal execution. When we look at heinous crimes, association to trafficking, drug dealing, they represent 32%, 39.2%, but this represents only the first half of the last year. And in the past, we had 88,000 people, and this represents 38.8%. I think that it was discussed here in the first panel how important it is that we rediscuss the drug politics in Brazil, and how much this also goes through an anti-racial war. We don't have data on race and war, race or other sort of minorities, but if we get the cut of the population in general, the monitored population is not far from there. It's a population of low income that is vulnerable, low school level, low qualification, and most of them are black or brown. These are the principles that guide. I have highlighted many others, such as the principle of data protection, but I have highlighted the principle of human rights. And this principle reminds us that it's important to respect the fundamental rights and the fight against the stereotypes. A lot has been said about monitoring being seen as a benefit, and this is a serious issue because people say, oh, the person is having a benefit, therefore they do not deserve any more rights. So the principle of dignity and freedom highlights that the application of EM must not be forms of fulfilling or paying time. and the principle of normality that says that the measure should be applied in a way that doesn't cause much impact in the routine of these people. This is the idea. Otherwise, we put these people back in jail. The idea is that they have a routine that is close to normality as possible. We know that the anklet by itself causes damage, so we cannot add more to it. I bring to you as a guideline a document that was produced in a partnership in the past, CDPN and CNJ. The model of management for EM of people is an important model. It is a tool to guide the works of the centrals. It is very thorough, and it's very delicate because we see that some centrals still do not make use of this model as a base or as a reference for the development of their actions. And the model is capable of offering to us from Senapen parameters so we can assess the policies in the 27 Brazilian states. How can we assess? Well, we cannot use experiences of common sense to assess a national policy. We need de facto scientific documents to assess the execution of the policy. Another issue that I like to highlight in the EM is that we need to differentiate economicity from effectiveness. The EM must not be valid only because it's cheaper than maintaining people in physical jails. It must not be valued only in the economical perspective, but especially considering the unfoldments and the negative incidents in the social context of people. Therefore, we need to think what is the possible level of social reinsertion. I mean, are the principles of this policy being respected, such as minimum intervention, human rights, and the protection of rights of people, of data of people? This is what makes the policy be effective, and not the fact that it is cheaper. I also bring to you the issue of the teams. It was said here about the importance of the work be followed by the multinational teams that are teams formed by lawyers and other authorities, other professionals, psychologists, for example. The lack of such measures renders difficult the efficacy of the judge because the judge does not follow the people beyond the sentence. The one who's going to do the follow-up of the person is not just a registration of the area of inclusion and exclusion, and that's it. The policy, the person needs to be accompanied in their everyday life. So from these reports that the teams produced, the judge can understand what is the profile that adequates to the policy. What is the policy that he is sure to apply, knowing that the measure will be effective. So we have a scenario that is very concerning. The amount of technical professionals that are required and recommended, and the workers, the team workers who are actually working now. So the more we have in the States is 39%, which is way below what is expected. All of the Brazilian states need teams. The states that have, there are 11 states that do not have teams, and the ones that have, sometimes they work with one single professional. And professionals who are really committed, who have a lot of willingness to do their job, but they need conditions. In addition to having the teams, they also need to have the capacity, the effective capacity to do that. They need to have their ethical code respected. They need to have a room to see people, and the secrecy of these services must be respected also. Here I bring to you the graph, especially that graph in orange has the states, the blue graph showing the teams, the orange shows the states that have agreements but they don't have a team, and the lack of teams is very much concentrated in this middle eastern part of Brazil. Why are they more absent in this geographical part? So, according to the data of Sistapen, we have 91,000 people being monitored in all of the country, and to have an ideal monitoring of these people, we would need more than 1,500 people specialized in this area. And we have 117 people, way below what is necessary. So the challenges that we face daily, in fact, are related to the lack of consensus in regards to the application of services. We have 27 states, and each state understands monitoring differently. For example, a full discharge of battery is capable of creating a violation of the monitoring system with the launch of flee of the monitored, which may lead to calling the police and the arrest of the person. There are states that are very much police oriented, exposing the dignity of the person. The expansion of the surface is not structured. It's situated, as I said, basically in the penal execution, and is not configured as an alternative to imprisonment. Especially, there is a reduced space for the person who is monitored as a subject of this policy. So the person is not being considered, is not being regarded. The central is an extension of the prison and an extension of what is done in the closed regime. So we have a lot of challenge, which is to align the execution of services. We also need to deconstruct this idea of prison being associated with a policy of public security. We need a qualification of the data. We are discussing this a lot on how to refine the data, because you can't do public policy without data. In fact, we need to know our audience, and we also need to win over this social professional dichotomy. Prisonal system is not done with a single knowledge. We need a lot of knowledges. We need a lot of people. We need a lot of scholars, a lot of academic people. So we cannot do penal policy only with police knowledge. Everyone has their importance within their scope of activity. Strategies of strengthening of the policy. We are divided into axes. We have an axe of strengthening of the networks. This is something that is not easy, because we know that this issue of the network will vary a lot depending on the region. For example, the South is one that has a more strengthened network, and then when you compare with the North, for example. And that makes it a little difficult, the access of the monitored people. We have discussed a lot the interinstitutional relationships. We are now dialoguing with the states to be able to produce mechanisms and instruments of assessment. We need to, in fact, define what is valid, and we are also learning what is being executed in all of the states, and we need to understand what is valid and what is not. We are also in articulation with other ministries with actions that involve men who are monitored due to protective emergency measures, and women that use PR, considering that the PR doesn't always show the security of the woman. So we need to make use of these people who commit these kinds of crimes. We have been following a lot of the money that is invested, and we want to invest as much money as possible to the strengthening of these teams. Also, we need to think about methodologies and mobilize this culture of data. We need to bring science to the prisonal system and end with this idea of treating people based on common sense. We are also closing the dialogue with the multidisciplinary teams that will give us an idea of how is the thing deeply. We have also thought of technologies, elaboration of technologies that are less stigmatizing. It was good that the professor talked about the cost of these anklets, how there is a lobby around this thing, and I use the metaphor that this is like a water faucet. So some people say it's cheap, but if you compare the investment that is made in other policies, it's actually not. It's like a dripping faucet that is always leaking water. So we need to think about the fomentation of the teams for the increase of knowledges and the inclusion of new professionals. We've actually seen some states in which they present statisticists and nurses, something that we need to think so that we can have better teams composing the teams. Guidelines, especially regarding the monitoring of women. We've seen, as we see the teams in a recent meeting that we had with all of the states that have a team, And a state in the south brought a practice that is pretty interesting. The team started a movement that became a rule, the removal of the anklet of pregnant women for 15 days, and the women always put it back. And this is amazing. The team working on self-responsibility of the citizen. And the state, in the state of the north, because of the proximity of the team with the judiciary, the team itself receives the documentation of the woman, they analyze, and then they go on to the hospital to remove the anklet, and then the team tells the judge. This is only possible because the judge is hand in hand with the team. So for us, when we have the judiciary closer, that helps the work of these professionals. These professionals, they need to count on the support of the judiciary, and therefore we have a better valuing, more empowerment of these professionals. So here I bring to you, since I'm coming to the end of my presentation, I bring some dilemmas. We have many ethical dilemmas that involve the electronic monitoring. It is good to remember that ethical doing is not prescribed. It goes through a constant process of criticism and reflections, and barbary should not be the norm. We need to change the treatment to people who are in physical jails and people who are in open regimes. We need to turn the key and change this culture that people, just because they have committed a crime, must not have their rights and must not have their dignity. So, good practices or best practices is the pathway for us. I end my talk thanking you for the opportunity, thanking the invitation made by C&J, and tell you that I am at your disposal. My contact is here. This directory, our directory is actually here. Almost all the team is here watching us live. So our doors are open. So you can come talk to us, exchange studies, products, projects. I think that now is a time when we have people from other countries watching, and this is very important for us, especially in this process of construction of a policy. Thank you very much.
Thank you so much, Ms. Emanuele, for your speech, for sharing with us the different strategies of the policies of strengthening that are being thought from Senapain's perspective, the sector that is so fundamental in this process, a partner of ours. So listening to you regarding the qualification of the data, the strengthening of the networks, the municipalization, the fostering of the multidisciplinary teams, all of this is extremely proficuous and help us so much to understand that these strategies are being thought of and being developed. I wish you all great success in the conduction of your secretary. And now, continuing with our work, I'm going to pass the floor to Mr. Sandro Loma, who was from the penitentiary system, and he was a founder of the association Mais Liberdade or More Freedom. It's a LGBTQAI plus, and he is from the prisonary system of Mato Grosso State, from Cuiabá, and from Várzea Grande. Since 2019, he does researches with the LGBTQIA plus in the Mato Grosso State Penitentiary. Good afternoon, everyone. I would like to thank everyone in the name of Carolina Teixeira and the CNJ and everyone that is watching virtually and in person. I would like the ceremonial team to put my time here in the screen because I have a problem with keeping track. I need to have time to understand how fast or how slow I need to go. So please share it in the screen so that I can program myself mentally. First of all, I'd like to thank you all and congratulate CNJ not only for this event, but all the different activities that CNJ has done for the penitentiary team in the LGBTQAI plus in a country that kills so many people from this group So the resolution that guarantees minimum livings in the prisons allows us to be alive now to talk about the electronic ankle devices, anklets, and the general judge who has invited me in this area, and I was shocked with the narrative of the situation of the incarceration in the federal district, that it cannot enter in the penitentiary area when you are LGBTQAI+, who is a leader of the execution of its court. So I would like to congratulate and thank Mr. Geraldo for having such a progressist view with GMS and all of the other representatives hereby. As Dr. Fernanda said earlier about the visibility of the women, I would like to talk about the double invisibility of LGBTQIA+ that are in prisons or that are outside of the prisons now. Now, we have been developing this with many partners from GMF and the Secretary of the Pastoral, Carcerária, the judiciary power in our state of Mato Grosso, and so on. So in here we can see some general data. I'm going to try to be as succinct as possible, but the there is a population that is still very young in our state. This is the data that we have. I think that my PowerPoint is not well configured here. I think that was an issue, but anyway, I think that you can see the data here. So a great majority of the population here of LGBTQA+ is black and is recognized as black or mixed race. In regards to the literacy, we have a low literacy to this group. We have um, people that are very bullied in the school. That's why they do not go beyond the high school. And when it comes to the people that go to jail, they end up not continuing their studies as well. We are doing the census of LGBTQAI+ in our state without of the units that possess groups in the women's group. They don't have specific areas. They cohabit together. We have asked these groups if they have already suffered any discrimination due to their sexual orientation when they were young, and 53.5% says yes. And they have stopped studying because of the discrimination. 32.6% said yes, that they stopped working because of this bullying. And when we make a cut about the people that stopped studying, we see the vulnerability that is even higher for trans and transgender and travestites as well. So they are transgender. So we continue having this population that is extremely vulnerable in here. So when we talk about the people that left the penitentiary system in the recommendation of non-electronic monitoring devices, when because of situations of robbery and drug addiction, is not what we see in practice. We see people from these areas using these electronic devices in the zones of drug addiction in our municipality, in our capital, and in our state. And therefore, when we ask about what is social justice and how it's done, it's not with anklets and not with shackles. We simply do that in infinite cycles of entrance and leavings of the penitentiary area. So the person is a user, so she ends up robbing or committing a small act without violence and is held in jail because she is addicted to drugs and she suffers the violence of the police officers, the way they approach them, and in the great majority of them, I'm going to skip a few slides here. It was asked in our survey if they needed to prostitute, and 78% of them said no, and 22% said yes. It seems little, but when we do a cut by gender, of the 22%, they are gay or bisexual. The ones that prostitute are transgender or transsexual. So are the people that need prostitution to be able to exist. And automatically they end up violating, I'm sorry, those are transsexuals and transgender that end up violating the time of the exclusion zones or of the anklets, or they go to the audience hearings and they go back to the prisons. I was here yesterday knowing two programs of people who left the prisons, and I thought that it was a problem only of my state. And speaking to a transsexual here, she said that she wanted a legal orientation, and I said, I'm not a professional, but what can I help you with? She is using an anklet, working on a social project, and she only receives 1,500 reais per month. And I said, how much do you pay for your rent? And she said 650. And light and water, she pays 100. So she has 320 reais to live. And she said, what are your problems? Of time, because I need to do service at night. So if we don't guarantee food, water, study rights, and we continue replicating violence, poverty of these people. And it's incredible how we think about social justice with a device that so many experts have already said that it's a device that is embarrassing for the majority of people. Several have talked about the fact that there are even chips that are implemented transdermically, but we continue in a necro policy having huge devices that are not for monitoring, but for causing this shame publicly, this public shame. So the heat of Brasilia is big for you because you don't know Cuiabá. It's 40 degrees in the shade, and you need to use long sleeves so that you hide your monitoring device. So imagine, it's crazy. So they also use socks or the anklets from soccer players so that it's more compact and the light don't appear. So since the climate is also very high, it impacts very much in people's health as well. So in Cuiabá, in a 40-degree sun and heat, they need to cover themselves with the muslins jihads so that they take their children to school or to go out with their children. And they cannot use a short clothing or else they're going to be discriminated or even approached by the police. So when we talk about the mothers that are having house arrest, it's also something that we deal in our institution. We talk about the obstetric abuse. It was already mentioned here. How can a mother go to a surgical center with with a shackle? And the what we receive, the testimonies, is I don't want to feel so ashamed. My son is already going to be born in this situation, and in practice, for us who assist them one by one, it's very painful to hear that. I'm going to go back a little bit. So it's questioned in our census. The census is partial. We're still doing that in all the states. This is just a small area that was analyzed, the metropolitan area with 47 people, about the difficulty that it is to find a formal job. There are many people that think that gender identity is an issue that I cannot see really well here, but I think it's 35. The lack of qualification, it's 30, 26, and the shackles 41%. So they don't see a gender identity as is a problem, but that these inclinates it are. So we have a trans um, person that receives a job in a recognized hairdressing shop, and she was doing a great job, and the owner said that she needed to leave because she wasn't welcome because she saw her device in the ankle. So this was a huge issue, and because of the lack of work, the lack of opportunity, the lack of public policies, when we think about all of that, the electronic device and the on the ankle makes we think about what type of policy we should help in our state, and we don't even have a place for people to stay in the shelters. We don't have units to specific areas for this type of people. And when we help them, or to even we recommend them services, they are forced to use clothing that are not part of their gender, and to use civil names and not social names. And the person that leaves the prison is monitored, and the only thing that is left for her is the drug as some type of way for her to live. We try to help this person to not be a drug addict anymore. But for if the only thing that the person can have is the drug, and we try to offer another service that she doesn't like, she doesn't stay there. She goes back to the street, she goes back to the drugs, and then she is back to the hearing, and she goes back to the closed regimen system, and increases the years that she stay in the prison. So there is an infinite cycle of imprisonment of this population. Without any further ado, I hope that you can follow our social media. And to end, I still have a few minutes to occupy the spaces. That is something that I would like to say. I remember when I was invited by the program Making Justice, Fazendo Justiça, in the UN office, and Mr. Geraldo said, "You have to go, you have to go." And Mr. Geraldo is helping us, but there is another person that told me, "But I cannot go. I have the shackle." And he said, "No, we asked for the authorization and you can go." We asked the request 1 week before, and the day of traveling, it was not signed yet. Only with the intervention of another judge that I thank her so much, Miss Rosie de Mirabal. She's our friend who intervened with the state for me to go to Brasilia to participate in this event right now with you. So we talk about social justice, and it's very difficult for us to depend on the service, and it takes so long. The lines are huge. So I'd like to thank the Public Defender's Office for what they were able to do, They work miracles, but the lines are huge. Until the person is able to have this service and to be appreciated by the public ministry and the judges, the person has already lost the opportunity and we cannot do anything else. So when I came here, I have a lot of problems to enter and be going to the federal police to present the documents and so on. So it is a huge fight that we have to be able to survive in the society and start thinking about the reality in practice and the topic that we were talking before. What is social justice? We can think about anything, but this device is definitely not a social justice. It's everything but not social justice. It can be effective in domestic violence, in the prevention of crimes, where we can use this device as a preventive mean, but the use of this device is in an indiscriminated fashion only puts more people in the margin of the society, discriminating and criminalizing them. And when I say that, some people approach the situation of the territory and of the family, and this is not extended only to the families, but only in the law we see that, because when you see your child, your son, your daughter not being able to participate in a playground and they are not accepted, and they say if you participate your father is going to kill us, and when you see your family being harmed because of your device, you prefer to stay in the prison instead of seeing your family feeling shamed of you, feeling ashamed of you. You are isolated in a wall, and people only go there to visit you, and you feel ashamed, and not your family. But when you take this embarrassment to your family, so this device cannot be considered a benefit in any way, and much less be considered as uh, some sort of benefit. I don't know what's worse, if it's being monitored in all of these conditions that I have just mentioned, or being inside the prison, knowing that the prison system is very cruel, the food is bad, but like many people said here before, sometimes it's better to be in a prison than in a place without food, without hygiene conditions, putting your family at risk. So, those are the reflections that I would like to leave to you that are very practical. I have taken my time to make this criticism as well, surrounded by so many authorities, so many technical reflections, just to bring you a perspective of someone who uses that. What is social justice and social protection with the electronic monitoring? That is basically it. It's not. Thank you.
Muito obrigada.
Sandro, thank you so much. First of all, thank you so much for your speech. I understand there is not a better authority than the testimony of someone who lived that. So this experience and the embarrassment of what it is to use this electronic monitoring practice. So around these authorities, in front of all of these authorities, your speech and after Dr. Emmett and Dr. James, who lived this experience, is very important for us to see that. So I would like to thank you so much to have been able to face all of these embarrassments, to be here with us today, sharing your experience and enriching this event so much. Indeed, we couldn't think about discussing the criminal justice without bringing close to us the experience from someone who is a victim of the system. So thank you so much for accepting the invitation and to having brought the data of the census and also to shed light of all of these intersectionalities that permeate the system that sometimes is away from the people that are not living this situation. So everything that you said was really interesting. So I congratulate and thank you so much. After I think our time is advanced and it's up. We're not going to have time to open for questions, unfortunately. So I would like to thank you so much for Sandro, Ms. Manuela, Lilian. Thank you so much for the contributions. I would also like to thank everyone from the auditory. So I would like to declare close the session and give back the floor to the ceremonial team. Thank you so much. I would like to thank everyone and to not compromise the last panel. We have 10 minutes of break now, and then we come back to the auditory.
an institutional video that was produced by the program Doing Justice, reminding you that in Brazil and in the world, the monitoring is always a challenge. This video seeks to introduce to the population why this mechanism exists and how it works. The video is available on social media of CNJ and on YouTube. We kindly ask you, ladies and gentlemen, to access and share in your social media.
Você, colega magistrado ou magistrada, percebeu que o uso da monitoração eletrônica cresceu bastante nos últimos anos, né? Neste vídeo, vamos analisar como isso impacta nosso trabalho na prestação de justiça.
A monitoração eletrônica é uma entre várias medidas que podemos aplicar em substituição à prisão, mas nem sempre é a melhor opção. Idealmente, deveríamos usá-la de forma subsidiária. Vamos saber por quê?
É o mesmo.
Essa medida é acompanhada por uma central de monitoração eletrônica, geralmente formada por profissionais da administração penitenciária, a exemplo de policiais penais. Há pouco contato com as pessoas e a lógica é manter o controle das restrições aplicadas judicialmente.
Na porta de entrada, o ideal é priorizar outras medidas cautelares nos casos em que a pessoa não seria presa se condenada. Essas medidas são acompanhadas pela Central Integrada de Alternativas Penais, ou serviços equivalentes, formado por equipes interdisciplinares, incluindo assistentes sociais e psicólogos. Enquanto supervisionam as medidas judiciais, esses profissionais conseguem acompanhar outras necessidades das pessoas, como trabalho, renda, moradia, atenção à saúde, entre outros.
Nos casos em que a monitoração acompanha o final do cumprimento da pena, é preciso lembrar que o uso de tornozeleiras pode intensificar estigmas e preconceitos no retorno ao convívio em liberdade, dificultando inclusive o acesso a oportunidades de trabalho.
A monitoração eletrônica é uma ferramenta importante à disposição do judiciário, especialmente se aplicada de forma individualizada, considerando as necessidades da pessoa monitorada e equilibrada conforme previsto em lei. Ao valorizarmos a autonomia das pessoas que tiveram contato com a justiça criminal, abrimos caminho para a integração social harmônica prevista na execução penal, construindo um futuro mais seguro e inclusivo.
Para saber mais, acesse as diretrizes e procedimentos do CNJ para a aplicação e o acompanhamento da medida de monitoramento eletrônico de pessoas.
Retomando a programação.
Resuming today's program to discuss electronic monitoring in Brazil following the light of international experience. We have Mr. Otávio Porte as the moderator, and as speakers we have the professor of Federal University of Brasília, Cristina Zaleski, the professor of the Federal University of Minas Gerais, Andréa Maria Silveira, the coordinator, the postgrad program of the University of Noroeste, Rio Grande do Sul, Michael Vermuti, and the monitor of the Doing Justice program, Isabela Pimenta. We hand the floor now to Dr. Otávio Porte. Good afternoon, ladies and gentlemen. It is with great pleasure that I will lead the second panel, the last panel of the second day of this conference, which is so important to all of the stakeholders of criminal justice and professionals of EM. We're now going to deal with a subject that is very relevant and fundamental subject, which is EM in Brazil under international experience. And for that, we have researchers and speakers who are very highly qualified. I would like to greet all the members of this table, of this panel. Ms. Cristina Zakseski, Ms. Andréa Silveira, Isabela Pimenta, and Mr. Michael Vermouth. Welcome, everyone. This moment is one of dialogue and exchange of knowledge, which is of great importance to the improvement and involvement of electronic monitoring in Brazil. It's important to look at international experiences through findings and systematized reflections, as well as on the presentations that will be made here. This represents opportunity of increasing our understanding about the possibilities, the challenges, and the good practices related with electronic monitoring. The international experiences can bring valuable lessons to the development of policies as well as more efficient practices within the scope of Brazilian of justice in Brazil. With that said, and without any further ado, I would like to hand the floor to our first speaker, Dr. Cristina Zakseska. You have the floor for 20 minutes, ma'am. Thank you very much. And I would like to first and foremost greet everyone, all of the people who are present here and the people who are with us remotely. I would like to greet my colleagues here at the table and to say that it's a great privilege to be here seeing so many known faces with whom I have been debating this subject for a long time, students, male and female students, and when I saw the title of the conference as well as of this panel, I was very satisfied to know that the researches that I develop are being considered, and I know that Isabella Pimenta has a great deal of responsibility, and that's why I thank her personally for the invitation. And this is exactly what I do. I look at the international experiences so we can understand our own better. And this training only came with my PhD in the end of the year 2000 with a research that is very close to the ethnomethodology and is part of this criminological glance and to think the controlled the institutions and the market. And this is what I will talk about today. I had something I feel kind of bothered to being identified as someone who studies um, electronic monitoring. And people ask me, well, how is that? Do you study the equipment? I say I study the control, and I always think about how to decrease its violence. And I would like you to keep this idea in mind. My research trajectory started many years ago in my research group in the year 2007 as one of the first Brazilian studies, if not the first one, and I don't want to be the first one. It was the first one on the subject, but it was based on a hypothesis on the use of electronic monitoring on Brazilian prisons, especially here in the Federal District. And we are discussing the book by New Christ. And the media used to say two things: the increase of homicides during this period, as well as the non-return of the beneficiaries between quotation marks. A student who is a forensic expert alerted to me that when the deaths happened, it was the prisoners who died. So we did a statistic studies and the percentage of non-return was insignificant. Of course, in general, those people who live prison are in conditional are people who are already in the semi-open. So why would they leave? So it was clear to me that monitoring would be an expenditure that didn't make any sense. And I was studying at the time the movement of the market of privatization of the control of people with issues with justice. And I noticed that I would have an important point of investigation there. But it's never been an easy study. As the representative of an Israeli company that I interviewed in Argentina 10 years later after my first study, the secret of the business is the secret. And in an assessment that we did about the situation of Latin American countries, myself and Michael, with whom I have the pleasure of sharing this panel, we could notice that the less transparent part of monitoring has to do with the movement of the companies and the cost of the policy. And why is this so hidden so well, I wondered. And I had to dedicate myself to the study of the subject, even using fiction, as I did in this research group using the mode of the cinema. So I wrote two texts about it, one on a documentary called Body and Infractions that talk about the body, and another one about a movie called The Circle that has it is about a technological company that develops a lot of controls. But I cannot talk about all of the results, so I will just prefer to talk about some. I didn't spend all of these years studying electronic monitoring, but I returned to the subject upon invitation of a group to talk about this issue at UNPOX, which is the National Association of Research on Social Sciences. And in 2018, I went to study the experience in Argentina, which would be the first one of Latin America. And I found a program called Salir de la Cárcel, which is the leadership of, under the leadership of a group of prisoner, and there is an amazing program that she led. So I was able to think with more clarity about what actually interested me. I study ways of avoiding entrance or facilitate the exit of people from prison, which is two classic kinds of monitoring, front door and back door. And I learned a lot with this Argentinian study because it allowed me to make a comparison between Brazil and Argentina following 10 basic points, and I listed the things that are said based on literature, common sense. I didn't do a prior evaluation. I just collected elements and refused or not that which is said from the data, which is also an investigation under investigation on the meaning of meanings. If you are to know, if you want to know the result, the law allows for monitoring to avoid crimes and avoid reincidence. It also doesn't allow for, it reduces costs, overpopulation. It avoids the effect of incarceration, allows for the supervision of the penalties and the application of reprimands because of violation. It also controls the distance between people in case of home violence, and also it controls the use of drugs and alcohol. I came to the end of the investigation with a confirmation of 30% of this list. Of everything that is said, 30% may happen in these cases that were studied in Brazil and Argentina, but in fact I only had 20% of desirable effects, because after all, the last one that is listed is not a desirable effect. So in this 20%, I end up getting into the issue of other tables of conferences, but it is worth mentioning that the use of gender violence is a kind of monitoring that I say that it makes a lot of sense, because you want to avoid the deaths of women controlling their position and the position of the aggressor. Even though this is a strategy that may fail because the dynamic of violence of gender allows for a lack of control, but even so, the aggressor can always hire a killer. So I'm sorry to say about this, but we cannot ignore this hypothesis, and it's not mentioned again. But I can figure out why. Another thing that seems to be possible is the following. It allows for the supervision of the conditions imposed for the surveilled freedom. It is possible, I agree, but in Argentina, for example, the systematic violation of the conditions that are imposed in the monitoring did not have any answer according to the judges who are responsible for this in Buenos Aires. They used to say, you need to have a hearing, the public prosecutor needs to be there, and so on. There, and in Spain, I saw that monitoring is a way of behavior, a way of sharing responsibilities of the person who decides, in this case the magistrate, with the controller. Furthermore, it is worth mentioning that in a universe of more than 80,000 people monitored, such as it is in Brazil, it is very difficult that the monitoring is actually effective. It ends up being the same problem of the excess of punishment. How can you manage this mass of people? As an example of the lack of control that could happen, I can mention the case of the terrorist attacks that we had near Brasilia before the Christmas of last year, in which a subject that had the anklet participated. I wrote about it and I published an article in Safe Environment. And they asked me, I wondered, what kind of inspection is this that allows that a person who is monitored comes close to an international airport? And more, how can someone dare to make an attempt against a state when they are actually being monitored? It doesn't make much sense, but maybe it's the confidence that maybe the coup would work. In this case, the topic is very problematic in regards to the electronic control, because after all, it's not about technology, but a structure of control integrated by people that has an electronic component. So I study criteria for the monitoring, and I find it's actually curious when we think about the criteria for the use of this monitoring. That is not recommended to violent crimes, but we can think that a violent crime could be the only one committed by a person, while there are many reports of people who are monitored who are commercializing illicit substances that does not involve violence. The problems of drugs can be solved in another different way, as we will see. So I believe it's not the conduct that says whether or not the measure is right, but the functionality of the equipment. In other terms, what good is the controller to know where the controlled is if they don't know what they're doing? In 2019, then I went to Spain and I ended up doing a work about the Catalan case, which resulted in a book, Technology is the New Villain, that was published in Barcelona. The Catalan case came towards my concerns, but there are criteria in many senses. So an algorithm was developed for risk assessment called Risk Kavan, in what regards what is hired, because in Spain there are very few equipments that are available, only 100, or at least that was the number in 2019, when technology, the cheaper technology, which is radio frequency, which is the technology used, and according to the needs of the system of control. In other words, the Catalans do not follow the appeal of the industry. So there was a scale that was created, which is desired here somehow between the prison and nothing, distinguishing who is going to live without monitoring, who's going to live under monitoring, and who's not going to live. So there is a program of resocialization that is executed by the prison department that monitors the measures. The problem is the presupposes of this system. When we analyze the same way that they want to train humans is just like just like we train animals. A manager asked me, "Do you have children?" I said, "No, I don't. I have a dog." So he answered, "Oh, it's the same thing." So I need to highlight two elements, two important things in the case of Catalan. The control is situated in the reduction of incarceration, and that makes all the difference. There was the planning of the construction of new units, but it was left aside because the population is being reduced. The criminal population is being reduced because of the changes in the law against drugs. There was an ordinance that changed drug dealing that had a prison sentence of 9 years. The amount of drugs for trafficking also increased, and that changed the amount of people who were sentenced for crime against public health. I didn't know a place where criminal policy is to increase the intervention in open spaces. It's interesting because it comes from the idea of a transformation of the sentenced people that trained in social experience. They need to put into practice what they've learned. But the importance is not the technology, but the system of assessment referring to the risk that every monitored person represents. I'd also like to raise the issue of the duration of time, because if there isn't an assessment system such as the one that I mentioned in this last case, how can you remove people from the anklet, giving them back to prison? And this is the concern of many of the monitored people, as has been mentioned here. If there is a scale, we need to think about removal situations that is not just giving people back to prison. A radio frequency could be a scale, because why do we always use GPS? Who's going to check all of these movements? In Argentina, they have a WhatsApp group where they have the events related to monitoring. In case of violence of gender, but the number of monitored people is very small. Just imagine how crazy it would be in Brazil to have a WhatsApp group with all of the movements of the monitored people. Of course, the states have differences, right, among them. I would also like you to consider that people take to the monitoring their own life's conditions. I've had reports of families that sabotage the monitored because they don't want to keep them because they do not work. An Argentinian judge saw the case of a boxer that was monitored, and I would ask them, so aren't there more people who ask for monitoring to work? He said, no, no, they don't. But they're not able to get a job anyway. So this economical situation of Argentina is very complicated. But people in general do not question the issue of proximity with family that allows for resocialization. This is an aspect that I problematize. But people who live in cities and have all of the everything at their disposal, such as the pastor from the Good Morning Veronica. So what would be the inconvenience for these people? Even the routines of control are different. In the federal district, here where we are, people in high status, they go in different specific times. In other words, the mobilism standards are different depending on who is the audience. In Spain, I've interviewed business people, playboy, immigrants, all in the same group because they all came at the same time to explain to the controllers where they were. They came by car, they came by subway, some came by bus. I would like to make some final ponderations because many of them have humanitarian concerns. We've heard a lot about this here. People who are sick, elder citizens, pregnant women who need to take care of their families. But see, this is not free of distortion or negotiation. So two quick examples. In Argentina, there was a monitored person that had only one leg. And the judge used to tell me, we are to the point to remove this monitoring because it is causing damage to his health. The anklet is in the leg that remains. I couldn't understand how a person who has only one leg needs to be monitored. In another situation, the anklet was put on the on the neck of a dog. And a minister said yesterday, I followed a case and I reported that in a text called Anklets and Buttons, the Methods of Control in Argentina. And what I would like to highlight about the dog in Argentina is that the neck, the anklet was not passed from the woman's leg to the ankle, to the neck of the dog. Actually, it was put straight on the neck of the dog. I would like to say that any control can be negotiated. This measure, this decision of monitoring this woman was given by the judge who was mentioned at the end of Judge Alexandre Moraes da Rosa. He had to step away because of corruption accusations, but I don't want to insist on this, and I don't want to make a case about it and say that I have the truth about what happened in Argentina. But the fact is that the report of viability showed negatively to the case that this judge granted the monitoring that was applied directly on the neck of the dog. And that sometimes works as a joke. Sometimes I wonder, tell us that story. The people ask me, tell us the story of the dog and the story of the perro caniche. So the report of viability in Argentina involves the electricity and also in case of surveillance. If there is an alarm, can the police get there? But there are some distortions that are pretty interesting, such people who are monitored in houses that have no roof. So this report of viability is kind of controversial, let's say. So it's not just a matter of feasibility, but a matter of necessity, effectiveness, and we need to consider that as the system expands, new needs and adaptations rise, and new transgressions should be controlled. At the same time, we talk about prisons in open spaces, and we need to consider that monitoring is part. In that way, prison circulates among us. There is a book that talks about it that says it is impossible that as measure technologies are improved, people will be arrested. In that case, the difference between prisons walls and non-prisons will be blurred. It is possible that one day we are going to all be in prison without physical confinement. We could be trapped in many ways, and this is the title of my book, and it also shows this ambiguity. But it also indicates that we are trapped by technology. We are certainly does not imply inhumanity of the controlled. I would like to apologize to the people who have heard repeated things and people who have been listening to me for a longer time. But so long as the data do not show another direction, I will have to repeat some things. But I also understand that you may be listening to some of them for the first time. So I thank you for your attention and I say goodbye to you now.
Thank you so much, Miss Christina. Thank you for the relevant reflections. They were great and profound. So continuing our panel, I would like to invite now to make his contribution for the lecture, André Silveira. Andréa Silveira. First of all, good afternoon, everyone. I would like to greet my friends here in the table, the panelists, and people who are watching us online through the YouTube channel. I would also like to thank the invitation from CNJ and from Isadora Pimenta. We work together for the invitation and for the opportunity. I'm going to speak in this panel. We can talk about the international experiences and to compare with the Brazilian experience the topic of the re-incidents. How have I approached this topic after a while? We were participating in results research in CNJ, and there was a student who asked me if the electronic monitoring would reduce the re-incidents. But I had not studied about that, so I couldn't respond to him. But in literature, we could see, at least in the theoretical point of view, that this EM would reduce the re-incidents. So I started studying about that, and I wanted to show them what were the findings that I had with the study. So let's talk about the concept of re-incidence in the point of view, in the legal point of view. The re-incidence is when we have a new incidence of the same crime after there is an extinction of the previous crime. In the sociological point of view, it's a phenomenon that has different articles, definitions. So it can be a self-declared reincidence, and it can be according to a new penal procedure. This is a conceptual discussion. Here in Brazil, when we study this, we also see a controversy in the point of view of the percentage of reincidence. In the studies of Brazil, we have percentages that are very distant, like 25% until 75% of reincidence. So it's very controversial. But there are no controversies regarding the explanation of what reincidence is, which is the failure of the capacity of the prison imprisonment system and also the criminal practices and trajectories. I've brought here with me An article, strategic article that was produced by Igarapé Institute, was done by two friends of mine from the public security from and my friend Valéria Ribeiro, which is a very robust study in Brazil about reincidents. They have done a systematic review of 144 other publications and 120 theses, and they have reached a very good result. It's very robust. I'm going to bring some of these findings, the main findings, to talk about this problem of the reincidents here in Brazil. The first thing that they call attention to is that the reincidence is not random. It's a cumulative phenomenon in the life of the person, during, before, and the life of the person in prison. And they also bring a perspective of the main factors, the main findings of this review are the factors that are related to the reincidence. So the factors that increase the possibility of reincidence is the socioeconomic problem, the relationship with the family, having practiced the first crime in adolescence, and also the immediate left from the imprisonment system. They include the regulation of documents. People leave the prison without money to go anywhere and without documents, the resources to buy clothes or to even buy food. And the greatest demand of them is the insertion in the labor market. So also in the analysis that they have done, it's a quantitative analysis of all of the studies. The majority of the reincidence in Brazil, it's of 32%. And another finding that is really interesting is that the support programs have insufficient reach that are concentrated in the big capitals, so they favor the ones that have more structure, that know that have resources to go to the different areas to or even work in prison. The reduction of the reincidence depends on the network of protection of people under vulnerability in all of the phases of life. They have observed as well that there is a correlation, and it's not a causality, but it's parallel. The use of drugs and the practice of crimes is related. So policies of attention to the person that left the prison also needs to be done. And the study has also pointed to that the negative feeling because of the injustice they faced inside the prison in the execution of their condemnation is also related to that. And there are other studies that talk about that. And the stigma of the passage through the imprisonment system also impacts in the chances of obtaining a formal employment and can contribute to the reincidence. So why do we need to work to study reincidence in the EM? In Brazil, it's part of our literature and in the definitions as well. The electronic monitoring is that it says that it would reduce the reincidence, but since it would be a soft punishment between quotes, it would increase the reincidence. So some of the studies talk about it in a contradictory way. So what was done? I'm going to briefly mention that how people that defend the reduction of the reincidence through EM, they justify theoretically in the following way. There are no empirical type of studies, but all of them, they are theoretical. They say that a continuous EM generate a dissuasive effect, and they hinder this effect of having a reincidence from the person that left the prison. They know that they are under surveillance in a continuous manner, and it's easy to detect the person to not let them go back to prison. But a second theory says the opposite, and it could explain or justify the following: the theory of the routine activity, the electronic monitoring to track the person through the different places that they go to. The potential victims can be localized there, and the determination of the measurement of monitoring electronically can come with restrictions that can reduce the criminal effects, and it would help this person to in the involvement of in the crimes, articulating conditions, maintaining themselves at home, not going to places where they have drugs. And I'm not going to debate about the theories, but it would be possible to contradict almost all of them. But they are arguments that are frequently used to justify that EM would reduce the crime. And the third one is the criminological theories that have to do with the formal and informal aspects that are very interesting to understand the reincidence of the crime. In this sense, the reintegration and the social support and the inclusion of the labor in the market would be important when they are present in this monitoring, allowing that they would help in reducing the reincidence. So those are the theories that come with the great mechanisms to reduce the reincidence using the EM. That would have a precocious liberation from the incarceration system and to prevent pro-social activities. But how can we look for these effects of the reincidence? We have done a literature review internationally with looking for studies that would have worked with control groups. We didn't want the study to have verified only the percentage of reincidence of people that were monitored, but also that had the control of people that had a similar profile and that had committed similar crimes, but that stayed under the imprisonment system, and the other one that was with the EM. And comparing both groups, we found many studies about that, and I'm going to comment about them before we continue. So this is the a way for us to compare with the Brazilian experience. I brought a study from 2002 studying the efficacy of the EM, the supervision of the freedom of the male infractors or the male criminals that committed violent crimes in the state of Georgia. And the criteria of reinsertion was after 6 months not going back to the prison. Then there was no direct effect to the probability of a new crime returning to the prison. Another study that is one of the studies that is one of the most quoted ones in the relationship between EM and the criminal reincidence is from Mayo Wilson from 2005. They have done a review that investigated up to what point the EM affects the criminal behavior in a high or medium risk analysis. They did a meta-analysis of between 1986 to 2002, and they have seen a lack or a very low amount of studies in this area. And it says that EM constitute a tool to reduce the crime throughout the time. Other studies that we have separated as well. We have done a long study and review, literature review, and from 2010, Kilias in Switzerland have pointed that the findings of this monitored subjects had the reincidence between 12 to 24 months after the end of the EM. And Turner 2015 studied the efficacy of the EM in California, and they had they had many reincidents. And Monnery, Helnigli, and Kinsley in 2016 study had an experimental study in France, and they had the findings of the electronic monitoring effects with the same characteristics. The groups were followed after 12 months, and there was the inexistence of differences between the sexual and harassment crimes. Hanagali and Kansei, I don't know if it's here. It's a study that is a very experimental in France with a great sample with 306 offenders where 469 were benefited from the beginning of the EM, and 2,700 continued being in prison, and the findings of conversion of monitoring had an effect of long term, with the commitment of new crimes in 9 to 8% to 11% after 60 months. This colleague has a very difficult name to pronounce. I don't know how to pronounce it. It's a colleague from Germany. Actually, two colleagues from Germany in 2020, they have done a randomized study, and they have studied this after the end of the monitoring through the people that received this in external work in a house arrest, that after receiving the final sentence, they were allocated in groups, case groups and control groups, and there were no statistics change or big gaps between both groups, the monitored and non-monitored groups, after a follow-up from 12 to 36 months after. Two other studies, I know it's tiring, I'm so sorry about that, but Mark Hollenberg, that was accomplished in Sweden. They have studied cases that had a reduction of the incarceration sentence after the approval, after the measurement was implemented, and the results of the case groups and the control groups didn't have a huge change, and the results showed that the one that had EM reincidated less than the other group that remained in prison. However, it was not possible to see if that was the result of the monitoring or the other elements that were included in the program. We can discuss that later on. And last but not least, the article here that is part of the study here that I did last year, after the study had already been published, is of two Australian friends, Jane Williams and John Weatherman, which is a very nice study. It's a very robust study. It's one of the greatest studies that I've seen. They have studied 12,000 people that were submitted to monitoring, people that stayed in prison, that committed crimes that would lead to 12 months maximum, and they have accompanied the outcome after 10 years. So the conclusion of the study is the following: that doing the sentence in the EM reduces the reincidence in 22% in 5 years, and in 15% in 7 years, and 11% in 10 years after the sentence. And they have studied the trials after 2016. They call the attention that in this context that they have studied in, the EM both deviates the criminals to the supervision that is very intense while they work in their own unit. So it's very difficult to understand what is the active ingredient that worked. Was it the simple control with the shackles, or the programs of support to the teams, the multi-professional teams that helped in a multidisciplinary way all of these criminals? So what are the lessons learned? Well, the first thing that I would like to call attention to is that in the Brazilian review that was done about reincidents, we didn't find any study that has dedicated itself to study the reincidents in the context of the EM. So this is the first thing that we would like to say, that there is a lack, there is a huge gap in our studies regarding EM. In the international studies, they should receive criticisms as well, because we should have a more criterious understanding of the methodologies that were used, and there were fragilities. They are not really well, they don't have a huge scope, and some of them are older, and the monitoring length was very small, only 1 year. There was only one study that monitored that for 10 years. There were divergent results, and there is no guarantee that there is a huge difference between the ones that are in the prison and the ones that are using the EM. We assume that there is a different profile of the ones that were in prison and the ones that received the EM. And repeating once again, the majority of them had small samples and small controls of the individuals that were studied. That made it difficult for us to have a conclusion regarding the findings that we had, or how we can assure with a lot of safeness that this really reduced the reincidence or not. And also, we would like to highlight that also there is a difference between the programs regarding the network support and the inclusion of other actions. The authors themselves of these articles, they call attention to to this fact, and they recognize that it's very difficult to separate this active ingredient of many of the studies and the people that were monitored electronically that received more support socially of the multidisciplinary programs in the community, at work, and so on. And so the harmonized effects of this surveillances and these studies need to be continuous, following these people throughout the years and having more approaches of that in the community. Last but not least, we cannot generalize these results and say that they can be applicable. The ones that were positive and that showed a reduction of EMM can be generalized to all of the contexts and all of the people. And to remind you that the majority of the studies show that there were not a huge positive impact in the sense of reducing the reincidence. But the great lesson learned is that here in Brazil, we indeed have a gap of understanding of this relationship, and that now it's something very good for us to study in the agenda of our institutions of research. Maybe CNJ can also do that and study this topic. Those are some references. I would like to thank you so much for the opportunity. I leave here my contacts.
Thank you very much, Dr. Andrea, for sharing the data as a result of your research. Before handing the floor to the next speaker, I would like to make a correction. I spoke with Dr. Isabella before. The internal affairs never stops. I was very non-elegant when I failed to read the CV of the speaker. So I'd like to apologize, Dr. Cristina. I did not read your CV, but I will do that now. Dr. Cristina is a doctor on compared studies, an associate professor at ANB, and the coordinator of studies on security. Dr. Andrea has a master's in sociology and policy. She also has a graduation in medicine and a master's in sociology and a PhD in sociology and politics. She is also the associated faculty of medicine and researcher at the Center of Studies in Criminology and Public Security of Minas Gerais. Now, with my correction, I will hand the floor to the next speaker, Dr. Michael Vermouth, who will also have 20 minutes for his talk. Good afternoon, ladies and gentlemen. I would like to greet the mediator of this event, Mr. Ricardo Porte, and through whom I greet my colleagues here at the panel, Dr. Cristina, Dr. Andrea, Dr. Isabella. And I would like to thank the National Council of Justice and UNDP for the opportunity to be here with you this afternoon, sharing part of some of the results of the researchers that I have been developing on electronic monitoring. All of these researches, they are part of a central issue that has been exhaustively mentioned here, which is the following. Electronic monitoring has been used predominantly as a mechanism of maximization of freedom or a reinforcement of penal penalties. So, starting from this idea and based on the principle that was a little different from that which was brought in the panel of 3 o'clock, it comes from another phase of Foucault philosophy. I believe that in countries such as Brazil, we can think of the prison system, or actually we shouldn't think the prison system, and as a consequence, the issue of electronic monitoring from the perspective of discipline or of a production of subtle bodies or political anatomy of the body, but we need to look at these bodies from the perspective of biopolitical control of the excess of the population that exceeds. After all, it is no novelty to mention here that our population that is part of the punitive system is a population that is marked by certain traces. We are talking about men, young men, poor men, black men, who have committed some sort of crime or are involved with some drug. When we look at the prison system for women, this profile also seems to be present. We are talking about women who also have the same features. So I've prepared support material for my approach, and I hope that it serves this purpose. My research is my research is within 3 projects that are being developed simultaneously. The first one is with the financing of FAPESP, which is a state fomentation unit from Rio Grande do Sul. The second one from PROCAD, which is CAPS, Public Safety and Forensic Justice. And the third one under the sponsorship of my research from the CNPq. I have the cover of 2 books that have been produced as a fruit of the researches that have been made. The first one has been published. The second one hasn't been published. It's only available electronically, but it will also be available soon in physical paperback so you can access. And for our discussion this afternoon, considering that I am one of the last people to speak after such a long day of discussion about the subject, I thought about bringing sort of a panel of synthesis about some of the issues that seem to be fundamental regarding the issue of monitoring in Brazil. And I would like to start from this central problematic that has been the guide of this discussion, which is a matter that involves the resolution of this equation imposed by the increase of repression. And in face of that, are we going to keep our prisons inhabitable and keep the budget as a way of facing this state of things in which our prison system is immersed? And I bring a reference of a book that I published a few years ago about the subject. So is the magnitude of violation of human rights in the Brazilian system that we did not even have a national institute that was able to name these violences, and we imported from the Colombian constitution a thing that is called the state of things that brings the idea of all of these violations. And EM is part of this dialogue about the term in Brazil. And we recognize the state of things within the prison system. As has been said here many times, monitoring has been used in our country as a replacement measure as well as a precautionary measure, which is different from prison. We have this legal outline, and I would like to bring to you some limits and possibilities of EM coming from this presuppose that is not good in essence or bad in essence. This is why there is this idea of limits and possibilities, following some panoramas that have been outlined here in the country, some researches that have been carried in the country about the subject. I am speaking about studies that have been carried out within the National Council of Justice, and I mention many that are mentioned in the material that was distributed to the participants of the event. I talk about data that come from assessments from the pain, and I also talk about data that I myself have produced from the researches that I'm carrying out along with the National Institutes of Monitoring, the judiciary power, and also the subjects that are monitored in the state of Rio Grande do Sul, and I bring you some information regarding the ethical aspects, the research with people. And people need to go through some phases before the execution. And from this point, I would like to bring to you 4 limits as consequences of these 4 limits and 4 possibilities from them. And I start by talking about the lack of standardization in the implementation and application of the Institute in Brazil. This comes from the fact that we've had, as highlighted, different timelines in the implementation of electronic monitoring in our states. So there are states with more or less experience in this sense. We've identified in the studies that have been carried out a variability in the modes, and that includes ways of application, that includes the action or treatment of incidences. We've also identified the lack or disparity in the way how the teams, the multidisciplinary teams are formed, and also differences in regards to the technologies that are employed in each one of the states. We are hired companies that have peculiarities in regards to the device in each one of the states of Brazil. What does that generate? In the first moment, it generates legal insecurity, a difficulty in diagnosis about the measures, lack of knowledge about how the measure works. And this is the first national event on the subject with this kind of level and amplitude. So in fact, we are here making history. I believe that this event is being developed in this way. Lack of credit of the measure, which comes exactly from this lack of knowledge and because we don't have a public discussion about it. And it affects the principle of isonomy as the monitoring is applied in a very asymmetric fashion per se. But what are the possibilities that come from this scenario? Well, in a coordinating action and synchronized action between the judiciary power and the monitoring units, studies that are directly implicated in the measure, capacity building of magistrates, the establishment of operational standards, and I would like to highlight that Resolution 412 at some point tries to produce just that. I mean, a standardization or a definition of guidelines for the application and follow up of measures, especially in what regards its presumption of treatment of incidents. The second subject that I would like to deal with this afternoon has to do with the potential of stigmatizing potential of electronic monitoring that has already been the subject of discussions here. We're talking about a species of incorporated penalty or of a sort of bio-legislation. We're talking about an external equipment. There are people who think about the possibility of inserting the penalty in the body of the subject through microchips and other technologies that already exist and that could eventually be used with this end. It sounds like a dystopia or Black Mirror episode, but not so long ago. If we were talking about electronic anklets, maybe we would also think that this is unimaginable. So this bio-legislation of the body transformed this body into a criminal body. This electronic device tells the world about the potentiality that this subject behaves in a way that is harmful to society as a whole. So this virtual danger represented by the monitored subject and illustrated by the device is a representation of that which the minister mentioned in the beginning of the event, the idea of this scarlet letter. In other words, that subject that is being monitored carries with them such signature. As a consequence, I bring to you some excerpts of testimonials that were collected by one of our alumni, Jeanette Schubert, and this quote synthesizes what I said. In other words, now it's just as if the prison were in me. In part, I am the prison, and it terrifies me the idea of committing any crime and then having to go back to jail. So I also bring to you some news related to stigma, related to the use of the anklet, news of what happened recently in the state of Pará, in which people were removed from public transportation in a very extensive and violent fashion because they were identified as criminals and they suffered these popular violation. And from this point on, what are the possibilities? First of all, the idea that we are debating here, that we have been debating here since yesterday, which is the idea of electronic monitoring as the last resource. Assessment of the socio-economical conditions of the person who's going to be monitored. In other words, we cannot establish the lowest level. We need to analyze everything. It is important that the decisions are based on good facts, and also it's important to be able to reassess the measure, because from the moment that this piece is put on the person's body until a new assessment, many things could happen. And so this is why it's necessary to do a reorganization of this electronic monitoring. Investment in technology, and I bring to you two models of EM, and it seems to me that the stigmatizing load that it brings in the most discrete model is less, and the model that is used is the bigger one, which brings even more stigma. And also the issue of the investment in policies of reinsertion that depends on the training of teams. In this afternoon, Manuela was talking about the need of thinking about the composition of the professionals, so that in addition to judges, social assistants, and psychologists, we can also have other specialties involved in this follow-up. And I found the idea amazing, especially when we connect that to the health. The third limit has to do with the lack of a multidisciplinary team. It seems that electronic monitoring requires the work of the agents, and some states count on these teams, others don't. Sometimes the work of monitoring has been developed in the context of the centrals by agents who are profoundly contaminated with a more punitive bias, and this ends up implicating significantly or reverberating in the way how the measure is supervised. As a consequence of this, monitoring is no longer an alternative to imprisonment. It becomes an extension of the imprisonment that goes beyond the wall of the prison. The purpose of electronic monitoring in this case is limited to this feeling of constant monitoring by the monitored person. This is what Campillo calls it, prisoner of oneself. And this also shows this disconnection between the measure that foresees the accompaniment, follow-up of these authorities. And as for the lack of support, it also impacts on the lack of clarity in terms of specificity of the equipment. Sometimes this information is not clear, or full of blank spaces, and also the language that is used could be difficult for the person who is being monitored because they are not able to understand the lingo. And as a possibility, we could think in the sense of transforming electronic monitoring in a mechanism of social laboral capacity of the people who are monitored, providing them capacity to study, work, other cares related with their children, especially in those situations that involve elder citizens, people with physical disability. And like the speaker at 1400 hours mentioned, such as involving physical activities, and this can only be done by the multidisciplinary team that will assess the every situation of every person who is being monitored. In other words, these are the teams that will be able to elaborate reports through which it will be possible to serve as the basis for the monitoring replacement of a monitoring for another measure, for example, that is less harmful to the citizen. Another limitation that I would like to approach has to do with the affection in the monitoring that has already been mentioned here in several times. Without the follow-up of the person who's being monitored through the use of extensive electronic and who that cause physical and shameful, for example, such as in the case of the woman who was giving birth, who got a shock. There are people who have their body hurt because of the contact with the material that composes this anklet. And all of this could generate problems related with the health of the user. And when this is imposed through criteria that do not meet the social cultural specificity of the user, and when it is employed in a banal fashion. So in these cases, electronic monitoring could become a cruel penalty. In this case, we would have as a consequence the violation of human freedom. As Dr. Cristina said, it adds to the deprivation of freedom between quotation marks traditional freedom, like Dr. Ricardo Campelo said. The penal system no longer recognizes its limits, and the prison becomes electronic prison. It starts to walk among us who are out of its walls. As a consequence, look at how this can be manifested in addition to all the testimonials that we heard this afternoon. Once again, the diary of this field research of Janetti. In the month of October, I went 3 times to the residence of the user. In one of these visits, the mother of the user said that he had, between quotation mark, he cried all night long. There was no medication at home, but he couldn't go because he didn't get authorization. He couldn't seek medical service because he didn't have authorization from the monitoring central. On the other hand, we can say that this bias is also shown in the statistics that show that electronic monitoring is an alternative to prison, as from its implementation, people who are incarcerated never stopped increasing. So the number of incarcerated people never stopped increasing. So we are composing this imprisonment with electronic monitoring. And this could be just another control of imprisonment, then a way of correcting or providing correction to the citizen. And this event is going to leave a great legacy. We need to think of monitoring as an extension or an instrument of extension of freedom. If there are rights, it is because of that. That is the basis of our republic. That needs to be greater than any call for public safety. So human dignity should be the one that measures all of the criterias, and from that point on we need to see if the measure follows its purpose or not. And here I bring a provocation that has already been made this afternoon. In other words, in what point should we think about dissociation of the equipment from the person's body, just like we like to turn off our phones at the end of the day, for example, and think, well, now I'm not going to be in communication for a long time so that I can lower my adrenaline. So why not think of allowing that a monitored subject also has these moments of dissociation of the equipment? We haven't advanced yet in this discussion in Brazil. And a final reflection that who controls the controller? After all, we are discussing what the monitored subject can or cannot do to change the monitoring, but sometimes we forget that this issue, I mean, that the person who can tamper with the equipment or with the system could be the people who are inside the system, taking care of the system. I'm sorry if I took more than the time allotted, but my time is up. Thank you very much.
Thank you so much for your rich enlightenments on this topic. Some questions already arise in my mind, but I'll leave it to the end. Once again, Michael is done a postdoctorate by the University of São Paulo, the coordinator of strict census law of UNGI and the Northeast, and as everyone else in the table as well. Without any further ado, I will pass the floor to Isabela Pimenta. Isabela Pimenta is a PhD and master in the program of postgraduation of anthropology in the Federal Fluminense University. Has elaborated a model of management of EM for people in the PAN and UNDP. And also in 2020, also she has done a correctional service of Canada fellowship in governance in Brown University, has worked in the Ministry of Public Security in Canada, and currently works here in the program Fazendo Justiça between CNJ and UNDP. Now, Isabella, you have the floor. Good afternoon, everyone. I greet Mr. Otávio and my professor Andrea, Cristina, Michael. Thank you so much for having accepted the invitation to be here. And to all of you who are here with us as well, watching this event. It's the first event that we have in Brazil about this. We have the law of EM since 2010. After 13 years, we start having a discussion at this level, bringing people from different parts of the world and in Brazil as well to discuss a topic that is so dear and so deficient at the same time, the point of view of studies and research in Brazil and the world, as we were able to see. There are several things that we think about and our foreign friends know about that. And in the name of the Fazendo Justiça program of CNJ, I also like to thank my friend Zuleika, who is my double in the organization of this event. So also I would like to thank everyone, all of the workers who are here with us, not only in this event right now, but also who have worked so hard for all of this to be able to take place in the best way possible. Although we had some problems with the time, I apologize for that as well. I'm going to try to be not too repetitive because were things that were already mentioned before. Some colleagues may already have mentioned them. I'm going to try to speak slower so for our translators, and let's go. So I'm going to start talking about the compared dimensions, horizons, and challenges for the EM of people. And I'm also going to bring some concepts and some plural concepts. That means that we don't have only one understanding of EM, which is natural for anything. So So there was a change in this way. So we have several concepts, and another concept that we have some paradigms that permeate the electronic monitoring as well. I'm going to bring also a legislative cut, but I won't tire you with that. I will do that briefly. And we have some data as well that I'm going to bring to you regarding the people that are deprived of liberty and of EM, and finally, what we want in the future in terms of EM in Brazil. The concept, like I said, we do not have only one concept for EM. It's not our purpose to have only one concept. The important thing is that when we work and when we do a research, we need to differentiate a concept, understanding that the concept has is impermanent change because the technologies and the services of EM also are evolving with time and being modified as well. What we can observe, at least in the concepts that exist in Brazil, is that the electronic monitoring, as well as the realities that we have heard before, it is a penal control and disciplinary surveillance, oversight. And being this so is a penal control. It cannot change the behavior of people. They are not going to change their behavior because they are using this anklet or this shackle. So it is important for us to hear from the media that people committed a crime while they were using the anklet. That is very common. Why? Because, especially in Brazil, we're talking about services that are based essentially in the control. We don't have, when we look at the Brazilian reality, services of probation, we don't have that, and a follow up as well. This supervision of the electronic monitoring, although we have a decree, a law that talks about this and says that this should exist in all of our services. But that is not our reality. So the electronic monitoring doesn't change the subject. The person is not going to change her mentality just because they're using anklet or a shackle. So it's important for us to have that in mind. It doesn't provoke necessarily and automatically a change, and the person doesn't follow rules and social norms because they have this anklets. If there is no follow up of this person to a multidisciplinary team that is qualified for that and serves for this purpose, it's a team that has a continuous education to act in this area, and a person that is not going to change the behavior only naturally. With that said, I'm going to show some paradigms that we have in electronic monitoring. As we have already heard since yesterday, it's a mechanism at the disposal going against the racism, criminal social vulnerabilities, and gender inequality. So EM, like our colleague said before, Sandro, it doesn't promote social justice. On the contrary, the EM doesn't do resocialization or social reintegration. So that is something that we have heard many times, and I'm just repeating myself, but it's important for us to have that in mind and have good senses in when it comes to this paradigm and what is important in this area. And so, in this point of view, it's important we have the need to have structural change in the social justice and to strengthen the opportunities of our system. So I would like to share with you, all my foreign friends, that Brazil is a republic, is a democracy, very young democracy in constant threat, under constant threat. So we need to remember that we always need to strengthen the basis of the democratic state, and it's a worry that we have. During the recent years, probably you have followed our news internationally saying that our democracy was under constant threat, and we always need to keep that in mind when we have this monitoring. Do they have but they have rights, so they should have their rights guaranteed. They should access public policies and public services that were already instituted. With that said, they have the right to access the school, to access the hospital, and also, like my friend from Costa Rica said, to go to religious cults, all of this based on the normality type of norm that is predicted from the model of management that was published by the justice system in the PEN and with UNDP with the National Council of Justice as well. And in the point of view of the paradigms, it's important for us to think about other possibilities as well, to think about other alternatives to the penal code with emphasis to the restorative justice. It's important for us to think about the practices of the restorative justice to manage conflicts that focus on the responsabilization and not on the punishment of the people. We have a lot to learn. We still learn until today with realities of the indigenous populations, the Canadian population with NOE, when we think about the management of conflicts and also the traditional communities of New Zealand, when we talk about the management of conflicts focused on the responsabilization and not in the punishment, as the electronic monitoring has been put nowadays. We also have, like I said, the electronic monitoring in Brazil, implemented in 2010. Before that, we had some pilot projects. So it existed in Brazil before 2010, and besides the electronic monitoring, it is a law that is very small and it has a bunch of gaps. It is only one page, and it's a law that doesn't conceptualize what is monitoring. And in this decree, and people who are following this through the translation, it has the same value of the law that regulates the electronic monitoring. It already has a design of a concept of electronic monitoring. It has the first image in a legal way. So we have other concepts of electronic monitoring, like I said, in a model that orients the electronic monitoring of management, and in the resolution 2013 of 2015, the resolution of CNJ for custody precautionary of hearings regarding the alternatives of the penal code that are not the same thing, but at the same time they are subsidies. They don't have a specific concept. There's also the resolution of CNPCP of 2017 and the concept of monitoring. And more recently, we have the resolution 412 from 2021 of CNJ that is going to bring us concept about electronic monitoring, saying that it's a set of mechanisms of restrictions to freedom to people under this hearing and executed through technical means that can allocate its location. And when we say location, it's important to mention that we only have electronic monitoring through GPS, which is different from the European context that we have followed here in the different days. that we have been following here. So we don't have other technologies here because radio frequency is less stigmatizing, although it is an equipment that is also at the ankle of the person. It doesn't need recharge. With that said, the recharges in Brazil, they are basically accomplished through cell phone chargers. The person is attached to the wall for hours per day. They are oriented to not sleep while they are charging because they can damage the charger, and that is very common to happen because the anklets that are used here in Brazil, they are basically devices that are set in Brazil, but they come from China, the pieces. So they are equipments that are very fragile in the point of view of the technology, though they are robust equipments, but they are fragile in the point of view of the technology. So there is a need for us to have a institution that is able to surveil the quality of the equipment. So because when we talk about cell phone operations, if I have a problem with my cell phone, I have a legal apparatus that can help me in regard of the equipment that I'm using. So we need to advance in the sense as well, especially in Brazil when we have equipments that damage frequently, and the Brazilian state needs to demand from these companies in the point of view of the surveillance of these equipments for them to be technologically more adequate. And there are much better equipments that don't reach our country. And there's a problem with the pricing because the companies that have better equipments say that they cannot enter Brazil because of the taxations that we have that are charged here in Brazil. But we need to be able to solve this issue, this dilemma, because we have equipment of GPS technology that work in an autonomous way with a charge only one day, 1 hour a day, and they can work for 2 days. So the equipments that we have in Brazil, people need to charge more than once a day for 4 hours a day. And this is very complicated because if it didn't exist, it's okay, but we have much better equipment that would allow the person to have a better life and much closer to the normality, and which is what we defend the most. So it's not for the lack of equipment, but also not the lack of documents and all of that. We have reached a place and we know that we need to improve always, but we also need to implement these norms and demand the responsibility of this area. So I'm going to pass some data, especially for people that are from outside, because for people that are from inside Brazil, maybe this is repetitive, but we have more than 800,000 people that are deprived of freedom, and this is data from CISDEPEN that is connected to the Ministry of Justice in December of 2022. We are unfortunately one of the worst countries of systems of imprisonment systems in the world. We don't stop imprisoning people in Brazil. And in terms of people that are monitored, we have from December of 2022, we had more than 91,000 people that were arrested, that were in prison, And in the conferences that I participated, it's really interesting. I gotten to know some of our speakers here. People used to say, "Oh, you are from Brazil." People from the different companies with the eyes shining. Yes, because we are a market. In a way or another, we are very inviting to the industry of the penal control. These companies, they are very interested in us, and they were looking at me with a lot of interest, but they didn't know that I actually wanted to decrease the people that were being monitored. But they looked at me with a lot of interest, with a lot of thrill, because of the fact of us having so many people that are in prisons. And with that said, it's also important for us to look at the EM historical series in Brazil. The electronic monitoring was implemented in 2010. The first diagnosis that was done, I did it as a consultant in the Ministry of Justice. Is the battery over of the microphone? Thank you. As I was saying before, the first census, the first diagnosis was done in 2015 in a very rudimentary way. I did this first census sending worksheets to the states for them to respond because they are not obliged to answer. And here in Brazil, as it happens in the United States, our system of monitoring is decentralized. The states, they have the autonomy to talk about the monitoring about with their resources. They can receive resources from this area with their own resources from the state. And we have reached a data of almost 2,000 people, and we observed in the year of 2019, 2020 actually, more than 72,000 people, so we had a great leap. And we are still growing, and this number is still growing. Now we have more than 90,000 people. And this data is from 2022. I don't know how many people we have today. And we are almost reaching 100,000 people that are being monitored, I believe. It's a number that is growing and growing. So it's important for us to see that this doesn't serve in Brazil so much in the point of view that we have observed, and electronic monitoring is growing, and it doesn't serve for that. But in Brazil, it has been used in a semi-open regimen, which are the halfway houses in Canada, and it's a regimen of semi-open regimen that has been used very much in different states. There are no semi-open states in Canada. All of the judges apply that in the semi-open regimen, sometimes conditioned to the house arrest as well. We have a majority male population, but the female population is also growing as well. In terms of crime, we also have a great quantity of crimes regarding the assets, robbery, and That is what we see the most. And finally, reaching the end of our presentation, what do we want? What type of monitoring do we want in Brazil? That we want the decisions to be based in the principle of individuality, and it's not interesting when we have decisions that are made without looking at the trajectory of the person when the person leaves a unit and receives this monitoring. We need to know if the person has a house, and the prison sometimes can end the relationships of the family, and we need to understand what is that house. It needs to have electricity, because sometimes we only have GPS devices. It needs to be charged more than once a day. So there has to be electricity for that person. And it's important for the judicial response to be based in the individuality and the minimal penal intervention and the need about the EM. Is it necessary? Eh, And can other types of sentencing be used? And the social adequation. The person is under the use of alcohol or the drugs in an abusive way. Is the person living in the streets? So for that person, we cannot use the EM, but there's a series of people that have the EM in Brazil living in the streets. So they don't observe the social adequation in this point of view. And also, we do not have studies in Brazil talking about the time, how much the duration of using the EM. But according to the field observations with colleagues, research, the person can be monitored for 4 years, 5 years, and we don't have a parameter that can guide in this measure, and it needs to be provisory, and it needs to be revisited by the judges. And the small damage as well, it's important for us to think about that, and the normality as well. The people that are monitored, they are subjects of rights. And once again, going back to the need of these people having the access to the public policies that are already instituted, they are subjects of human rights. And another thing that is really important as well, thinking about the principles of the monitoring, is of the sensitive nature of the data that are being monitored and of third parties as well. So we do not have a legislation that talks about that. We have some protocols about that. We have documents as well that are recognized by CNJ that guide on the protection of data, but it's not observed in Brazil in a broader scope. So the application of the monitoring needs to be subsidized and it needs to be minimized, because we need to contain the geometric expansion of this control. And in the point of view of this control, according to what our national international literature says, is that we need multidisciplinary teams and central of EMs, people that can be in this area. So we need public tenders. We need to strengthen the careers that work with the EM, instead of only having more and more devices, because these teams, they already have a lot of workload and they cannot do more. So we need to also break the retrofeeding of the prison system, because we need to reevaluate the conditions of what we do, and the electronic monitoring, especially in Brazil, when people stay years after years being monitored, the life of the person can change. The person can start studying at night. The person can start working in a formal or informal manner, and it's important for us to highlight that the judges, they need to authorize the informal work as well. And in Brazil, we face a huge issue regarding employability because this is a country under development, as I don't know if I can say that, but we have difficulty to have insertion in the labor market when the person is using this device. Some judges don't allow the person to work in informality, so these people once again have their labor rights being violated, so they are not able to work. And we need to review that. So we need services that are based in protocols of data protection. We have materials to guide about that. Although in Brazil we have a law of general protection, data protection, it doesn't deal with the criminal justice, but there is also a lack about this area. And we also need to review what are the number of people that are being monitored and that go back to the prison. And it's important that the success of the EM is not the number of the people that are in prison because they have committed a violence during the EM monitoring. So, because sometimes the battery failed or there was a problem of the GPS communication, they go back to jail for months after they until they are presented in front of a judge implementing the EM or another measurement or decreeing another imprisonment. And it's also important to talk about the strengthening of the multidisciplinary teams in the treatment of these incidents to the access of rights and the fulfillment of rights, and of fulfillment of duties. And we do not have probation, but we have a law that says that we should have psychologist, social assistant, and lawyer in this central of EM monitoring. So we already have a horizon, in my point of view, that is designated for us to be able to implement. All of the states need to implement that at the end of the day. So it's important for us to have public tenders to hire these multidisciplinary teams and to have continuous capacity building for the penal actors and stakeholders as well. The electronic monitoring is also not indicated for all of the people. And a person of abusive alcohol use, the EM is not recommended, and the EM is also not recommended for people who live in the streets. So there's an entire profile that the EM can be a good option or not, and it shouldn't be implemented in all the national territory because we live in a country of continental measures, and the person that lives close to the river will have a problem of using this device because the signal will not be able to function, and the person who lives in farms as well. We have also observed decisions obliging the person to change houses because they used to live in a rural area. They had to change to be able to use the EM. So the EM, when we say that it's not for all the people, it's not for all Brazil because we have forest areas, we have also the importance to use that with parsimony. So it can be used, and there are other tools that can be used carefully. Going towards the end, we also have to have an extinction of arrest and research of people that are not monitored without the expedition of documents. In Brazil, we have a recurrent practice of groups that go to the houses of people and take them to prison without mandates that are issued in an individual way. It's almost analogous to the arrival of the Brazilian territory, of the captains that used to go to the different areas to capture the slaves and the indigenous people. So we continue perpetuating this practice that is highly selective, racist, and that goes against the poor people and black and people to the prison that never ends. So we need to break this process, and if the imprisonment needs to happen, it needs to be from a judicial point of view and a judicial decision, and this judicial decision needs to be individualized. We cannot go to different people's houses and just lock down people because they violated of this problem of battery discharge or a lack of communication or for false alarms, which is something that is very common. It's very common for the managers of the centrals of electronic monitoring talk about the failures of the system of EM. And in all of the countries that we had representatives of who talked about this, talked about the fragilities of these devices. So these false alarms cannot be a reason for people to enter the imprisonment system again. The adoption of technologies that are more autonomous and less damaging for people that are monitored. The monitoring needs to be done in a residual way. If they do take place, the team of electronic monitoring need to do this electronic monitoring in a virtual way. So if it's necessary for them to visit the person, it needs to be in a residual way. So it's important for us, once again, contain these practices that select the racism and the criminalization of the poverty that unfortunately continue to be a problem to the criminal services in Brazil. And similarly to the imprisonment systems, we arrest black, poor people that live in the margin of the society, and we monitor the same profile of people. So we need to stop that and to put a stone in this practice that has structured a good part of the social basis in Brazil. And earlier today, Judge Fábio was talking about that. We are a country that have a very refined type of racism. Unfortunately, it's not so explicit as the American racism. So we need to rethink to stop looking for people that are being monitored. So, like we said before, they are people that committed crimes and that have the rights that need to be guaranteed. Here are some references. I would like to end by thanking you so much. This is my email if you want to talk to me. I'm going to pass the floor back to the chairman of this table.
Muy bien. Oh, fantastic. I would like to thank all the members of the table for the lessons, for the teachings. I don't know if we have time for one question. I would like to give a testimonial of someone who was actually pretty concerned about after everything that's been said, so I didn't hear the other international experience and everything that's been said. But I was in Goiânia a few days ago, And I was really impressed with the things I've heard, the things I've seen, and I had access to some of the files, some of which I myself helped to promote. Rio Grande do Norte, the prison in Corado. It's true that for every complex problem, there is a simple solution that is completely wrong. And our problem here is one of the most complex. But supposing we were in Alice's world, a perfect world, that we could overcome all of the technological contingencies and we could have the best anklet in the world that could work via radio frequency, that was discrete, that is not invisible, and that would overcome the issue of taxation, and that the anklet could be considered. Let's say monitoring would be adopted as a national policy on a national level. I confess that I was a little surprised with Dr. Isabella's report. I actually expected to see a report a little bit more enthusiastic in terms of the results. But I confess that I've never been a judge of penal execution, even though I have a contact with some of them. And I've also seen the growth during the pandemic as a precautionary measure. Considering what we know, in what terms, if we had the equipments and if we had the social adequation at site, and so we would have courses, we would select who could effectively be monitored, excluding street people who live on the street, people who live in rural zones, and also considering the empirical data that we already have. How, overcoming this adversity, in what way, in what measure, monitoring could be considered public policy, considering also the regional difficulties, or considering the regional difficulties. And within a process of preparation to respect all of the principles of adequation, how could effectively this be a public policy counting in this world of Alice? I know that this is not a simple question with a simple answer, but I would like to hear from you. And I confess that I expected a greener view. In my question, I know that it's basically answered, but I would like to hear your considerations. Who's going to speak? May I? How do I turn on this thing here? Is it on? Yeah, well, let's see. We're going to start from Alice's world. Considering the Alice's world, and if we are to think about electronic monitoring as public policy, the first thing that we should have is public servants. So when we talk about electronic monitoring, we're talking in Brazil about police officers. So we need to have a spectrum of police officers taking into account the amount that is necessary and with the capacity to work in electronic central that is fully structured. So we need a central of monitoring with people working there, and they should be selected in a public contest. We need a public contest for the multidisciplinary teams, because when we have some central in Brazil that has multidisciplinary team, sometimes it's an I team. You can translate that, but it would be I team. It means is the team composed of one person, whether it's a psychologist or a social assistant working in a dispatch that controls 8,000 people, meaning it's impossible. So we need to have public servants. So I think that from the structure standpoint of a public policy, the first thing that we need is human resources. And when we talk about human resources, we're talking also about the need of initial training and continuous training. So we can't have an initial training and then never work with this team again for a refreshment. So from the executive standpoint, we need public context, and we also need continuous, initial and continuous education. From the judiciary standpoint, we also need initial and continuous education, because it's not all the judges that are familiar with all of the technical issues related with monitoring. So it has to come to them in the beginning of the work, in the middle, as well as until the end. So this is why we need to establish continuous initial and continuous training to the judges, to all the parties involved, who should exist in the monitoring, so that in addition, it is important also that we have an agency, as I said, that inspects the quality of the equipment. So when a monitoring center launches a bid, in addition to the technical specifications, there should be an agency that demands that the equipment works. Because what we observe in Brazil is that there are homemade solutions, solutions that people need to invent for the anklet to work, like put their foot close to the refrigerator for 10 minutes, put a spoon on the anklet, or maybe a screwdriver. So homemade solutions that do not work well, and that put people, monitored people, in a situation of vulnerability, because they go back to prison just because the anklet doesn't work. So there should be a public policy and an agency that oversees. The work is oversees the electronic monitoring equipment. And from the standpoint of the monitoring policy, electronic monitoring point, from the electronic monitoring standpoint, in order for it to work in the best way possible, it needs to look at the individual from the standpoint of their needs. Needs always based on law, based on rights. So how can we think about social integration if the people cannot work, if they cannot study? And when we talk about working in Brazil, we're talking about informal employment. I'm talking about people who sell stuff on the streets. We're talking about people who sell, for example, on the beach. So we need to have this legal authorization of people who actually work on the move. So we need to advance in that regard as well. So I think this is what it is. If you think about you need to think of the staff standpoint, as well as from the structuring of the equipment, and also of the central, because there are many centrals that they work in such terrible construction buildings that we also need to provide conditions for the servants to work. And this is not a reality that we notice in Brazil. So I think that this is it, the principle of individuality, of need, but focusing basically on the construction of a public policy. I think it's about strengthening the work of the penal police, as well as the multidisciplinary teams, with public context. It has to be a permanent policy. It can't be an outsourced contract, because it doesn't ensure that the electronic monitoring becomes a public policy that is serious. I think this is it.
Actually, I agree with everything that you have said. I would just like to compliment. First, in regards to the devices, I think that if there was an agency that was like Anvisa in the area of health, with an authorization of a device, it goes through a very rigorous evaluation of the damages that it can bring to the people that use it as well. And I would even say that according to that, the different problems that it may have, I'm just talking about burning people or shocking people. That is inadmissible. So those would be things that Anvisa would do, for example. And there's intersectoriality as well in this system. So in these different areas, we have the absence of access to other rights and other public services that the monitored person would have in their articulation to right and the social assistance and health, and this goes beyond this service as well. So in the Alice's world or in the Alice's land, this doesn't exist. Of course.
Okay, I would like to thank you for the provocation, and I would also like to add to this world, Alice's world, perspective, a political criminal perspective. So if we follow this idea of excess of criminalization, we are not going to advance neither regarding the monitoring or liberty. So I can only think of an improvement in this control system, giving room to other devices. And I was trying to think here about the scale, speaking of the memory, I mean, of the experiences I know, but also thinking in terms of cheaper technologies for control, and in situations in which the control is only being imposed because there is and because it is hired. Because in many of these cases in which people are monitored, they could just leave with a list of other possibilities of providing an answer to the system of controls, for example, of the precautionary measures that do not demand monitoring. That monitoring is one of its elements. So, the cases that I know, in the cases that I know outside Brazil, we've always worked with the perspectives that are very small, with a very much smaller scale, and so you're able to establish criteria for criterias. You could also have multidisciplinary teams, so you can associate the ideas of my colleagues that came before me within a logic which is also more publicized and discussed and clarified to the monitored population as well. So I believe that all of that articulated could provide a better result, but it's not the trend that I observe. So the trend that I observe is always of a growth that is more punitive, as well as a facilitation of return to prison of the monitored people for those cases in which there would be such a need because of the distortion of the use of this electronic monitoring. So I'm able to think of this world also within a process of discriminalization of conduct that we do not observe in Brazil. Thank you.
Mr. Otávio, while you were asking questions, I saw that Dr. Ana Isabel had answered in a very simple way, and Adriana also brought that. In this dystopia, this seems like we wouldn't have to think about monitoring, and considering that this has reproduced a profile of people that were monitored and also incarcerated. Dr. Isabel called me and other panelists as well, talking about the social bias and this cut of the racial point of view and the implications that it can bring in the structure and in the development and execution of this system of administration, in the measure that we could do that more and more. And I'll think about ways to dry ice, because at the end of the day, that is what we're doing during the EM. And in the majority of the days, we could get the resolution 412 of CNJ and send that to the National Congress, transform that into the law, making EM follow what effectively is written there. And that is the ideal world of the electronic monitoring. Like we said, this is already something that we have subtract to do. Thank you so much. So thank you so much for opening and closing the debate. Everyone has a very enriching experience here to bring to us. Like I said, I'm not a judge of execution courts, but I talk to many people, and they have their sadnesses, and it's obvious that the reference of the Alice's Wonderland is for us to start imagining a dystopy, a dystopic area. We have so many diversities, and so we can imagine the reality, and also the future generations. We need to work a lot towards that. So I thank you so much for the opportunity, for participating in this table, and good evening, everyone. We thank everyone here today, and with the due authorization, we declare finished our second day of electronic monitoring ethics, guarantee of rights and technology international conference. Tomorrow will start at 9. Have all a good evening.
Essa altura do campeonato a gente tem que descontrair.